Good morning, everybody. Welcome to TCF Live on a Monday, now starting an hour earlier. So early, I'm looking out the window of the bunker here, and there is no light. It is pitch black. Gotta love it. Welcome. We're going to start our day in Warren County, Ohio. This is the Court of Common Pleas. This is Judge Donald Oda.
I prefer just to have you as my juror and judge.
Okay. Let's talk about that after we get to the end of that, whether or not did I print out a counsel waiver? I don't think I did. I need a written counsel waiver. Maybe I can print that out. I just remembered about that. All right. So at the trial, you have the right to confront the witnesses that are called against you. Do you understand what that means?
Yes, sir.
What's your understanding of what that means?
That means you got the right to question the witnesses about the effect of what happened on that incident day.
Okay, that's partially true, and that's the most important part of it. But also, one of the things about confrontation, Mr. King, that some people tend to forget is you have the right to see and hear all of the evidence in the case, same as the judge or same as the jury. So no evidence is going to be taken in this case that you are not present for. If Ms. Tranter calls a witness, none of those witnesses are going to be permitted to step down from the witness stand until you have the right to cross-examine them if you're representing yourself, or if Mr. Engel's representing you until he has the right to cross-examine the witness. You also have the right to look at all of the physical evidence, which I understand that you've seen all the videos and that you've seen all the evidence, right?
Well, I've seen all but one video. That was the last video. He was telling me that it was blurry.
Okay.
So,
if there is any evidence that comes up in the case that you have not seen, Mr. King, I want you to bring that to my attention. Can you do that?
yes, sir.
All right. We also have the right to compulsory process. That means that you have the right to have witnesses come and testify on your behalf. And if they won't do so voluntarily, we can issue orders and subpoenas to make sure that they come. Do you understand the right of compulsory process?
Yes, sir.
I don't know if these witnesses, I think at least one of these witnesses maybe did not want to come. I don't know that we're at that point yet. I might be thinking of a different trial. But if there are witnesses, or this also extends to evidence, documents, those sorts of things, if you want to present those, we'll get those for you by the way of subpoena. Do you understand that?
Yes, sir.
You have the right to remain silent at the trial. It's kind of a bit of a sticky wicket when you're representing yourself, because you have the right to remain silent, but you're going to be talking the whole time. So if you try this case to a jury, I will advise the jury that you have two jobs in the case. You have the job as your own lawyer, and you have your job as the defendant. Unless you take the witness stand, raise your right hand, swear that you're going to tell the truth, all of those things, none of what you say at the podium or from counsel table, none of that is evidence. Do you understand that?
Yes, sir.
The state of Ohio is not allowed to call Todd King as a witness in the case. Whether or not you testify is up to you, and if you exercise your right to remain silent, I'm going to tell the jury that they are not to hold that against you in any way. If I hear the case myself, I'm not going to hold the fact that you remain silent against you in any way. Do you understand that?
Yes, sir.
Probably the primary reason that sometimes people do not want to exercise their right to testify in a case, and they want to exercise their right to remain silent, is because if you take the stand in the case, I would imagine that Ms. Tranter is going to cross-examine you about your prior criminal history, and it may be that it makes sense not to have that come in. Do you understand that?
Yes, sir. But may I ask,
Sure.
ask you a question? Now, coming to my prior history, everything I have is back from '79 except for 2019, so everything else is, can't be brought up anyway.
Yeah, I don't know what your criminal history is, Mr. King, but I can say this. If you're going to testify in the case, the jury is probably going to hear that you are in prison for the charge of felonious assault. If you don't testify in the case, the jury is going to know that you're in prison. They're probably not going to know why unless you tell them. Do you understand that?
Yes, sir.
All right. Do you understand what proof beyond a reasonable doubt is?
Yes, sir.
Okay. You're presumed to be innocent in the case. Do you understand what that means?
Yes, sir.
Essentially, what that means is, Mr. King, the state of Ohio has to prove that you are guilty. They have to do this beyond a reasonable doubt, which is the highest burden that we have in the law. If they don't prove every essential element of the case, then I'm going to instruct the jury to find you not guilty. And if I hear the case, if they don't prove everything beyond a reasonable doubt, I am going to find you not guilty. I'm going to give the jury an instruction that basically says, and I'm not reading it verbatim, but it's going to say that you have to, it's proof of such character that an ordinary person would be willing to rely and act upon it in the most important of that person's affairs. That's generally what the proof beyond a reasonable doubt instruction sounds like. Do you understand that?
Yes, sir.
So we have some rules at the trial, and one of the rules that we have is the rules of evidence. That's generally where most people who represent themselves run into trouble, because there's only one rule book, and I don't change the rules because you're representing yourself, even though I am going to make as many accommodations for you as I can. It's not fair, though, for me not to hold you to the same rules. Do you understand that?
Yes, sir.
Are you familiar at all with the rules of evidence?
Yes, sir.
All right. Do you think that you would be able to handle that part of it in presenting your case?
I believe so.
Okay, because the state of Ohio, they're going to be represented by an experienced attorney in the case. And I'm going to hold you to the same standard that I hold Ms. Tranter. You're going to have to follow the rules of evidence and procedure. What's really frustrating, Mr. King, and I've had this happen, when somebody's representing themselves, they have a document that they want to get into evidence. Everybody in the courtroom knows how to get that document into evidence. I know, Ms. Tranter knows, Mr. Engels, everybody knows except you. And it's very frustrating to watch somebody try to figure it out. Now, you're going to have Mr. Engel available to you as standby counsel, so you can lean over and ask him, hey, how do I get this into evidence? He might try to help you to the best of his ability. Do you understand that?
Yes, sir.
We've talked a little bit about this a couple of minutes ago. You have the right to have the jury decide the case if you want. That means that we'll impanel a jury of 12 people, and all 12 of them would have to be convinced beyond a reasonable doubt that you're guilty of this in order to find you guilty. They also have to have a unanimous verdict that you are not guilty, and if they can't agree, that's a hung jury. If you waive your right to a jury, I'll decide whether or not the state has proven beyond a reasonable doubt that you're guilty of this. You understand that?
Yes, sir.
Just to give you a brief overview of the trial, you've been through a trial before, so you kind of know how this works, but I'll tell you the way that I do it. The first order of business is what we call jury selection. That means that the jury that's checking in here in a couple of minutes, they're all going to be brought into the courtroom. Some of them are going to be put in the box. 12 of them are going to be put in the jury box. The rest of them are going to be seated behind you. Then we're going to have a process called voir dire. We're going to talk to the jury about what the trial is about. I'm going to explain to them a little bit about what you're charged with. I'm going to ask some questions about whether or not they can be fair and impartial in the case. You're going to get an opportunity to question the jury also. So the way this works is I will ask them the initial questions that I have for them. We have things called jury questionnaires, and you're going to get those jury questionnaires that you can look at during the trial so that you can talk to juror number 8, for example. Let's say it's Ms. Johnson. You can look at her and you can see that Ms. Johnson has, she's employed maybe by the prison, for example. You could talk to her about that, how that may affect her, whether or not she knows any of the people involved. The idea is to get a jury that is fair and impartial to both sides. I do limit everybody to 20 minutes for their part of voir dire. Everybody complains about that. I don't expect you to be any different than that, Mr. King. But that's the way we do it. Then we exercise what we call challenges for cause. That means if you think that any of those jurors can't be fair to you, then you'll exercise a challenge for cause. We may have a chat about whether or not they can be fair. I may excuse them, I might not. Then we have what's called a peremptory challenge. That means that both you and the state of Ohio have 4 challenges, which you can get rid of somebody for any reason or no reason whatsoever. We just excuse that person, put the next person in, and we go on with the voir dire process. Do you think you understand jury selection?
Yes, sir.
After that, I give the jury some initial instructions, and then we do opening statements. Opening statements are a preview where you can tell the jury what they expect to see in the case. Then we have witnesses, first by Ms. Tranter and then by you. Then, after the evidence close, we have closing arguments. Then we have jury instructions. If you represent yourself in the case, I anticipate that I'm going to have a draft of those instructions to you probably by mid-afternoon. There's already been a dispute that has broken out over the jury instructions based upon a case that I had with these folks not too long ago. So we're going to have a discussion about what the self-defense instruction should look like for somebody who is in a prison. Because when you're in prison, the corrections officers, they have a legal right to exercise some amount of force on you that they may not be able to exercise on me or Mr. Engel, for example. So if they tell you, hey, you need to move out of the way, and you don't move out of the way, they're allowed to push you a little bit to the side, what we call minimal or nominal amount of force. They're allowed to manipulate your hands, your feet, to put you in cuffs, those sorts of, all of those things are allowed. But then we also have something called excessive force, which means that you are subjected to force that goes beyond that. I'm not going to get too deep into that because if we have a discussion about that, it's going to be a pretty sophisticated discussion that's going to take place later. But it does have something to do with your legal defense. Do you understand that?
Yes, sir.
You're going to be shackled throughout the trial. So, you're serving a prison sentence for a crime of felonious assault. You're accused of felonious assault. This level of violence overcomes your constitutional right to be free from shackles during the trial. I do understand, though, that we have some civilian clothing for him. Is that right?
That is correct, Your Honor.
So you can be dressed out in civilian clothing, but you're going to be shackled. And as we talked about at the conference, if you sort of scooch up under that table, jury's probably not even going to notice that you are shackled. They might. I'm going to tell them not to worry about that it's just the same sort of thing that we do in every case. But if you're up moving around representing yourself, jury's going to notice a little bit more that you are going to be doing your lawyer type stuff, that you're shackled. Do you understand that?
Yes, sir.
Do you have any questions about that?
No, sir.
All right. The right to represent yourself is not the license to abuse the dignity of the court, to disrupt the proceedings, generally to be sort of a pest of yourself. If you become disrespectful or disruptive, then you will forfeit your right to represent yourself, and Mr. Engel will step in to begin to represent you. One of the things that is a little controversial amongst my judge colleagues, Mr. King, is what level of disruption or disrespect we have. When you're representing yourself, you may not talk the same way that I talk or the way Mr. Engel talks or even the jury talks. You may use offensive language, cursing, slang. I don't consider any of that to be disrespectful. So during the trial, I don't want you to search for the right word that's not going to hurt anybody's feelings. You talk the way you want to talk, and I don't find that to be particularly disrespectful. But if you're going to start yelling, if you're going to start screaming, pointing your finger, doing all of that kind of nonsense, that's disrespectful and disruptive. I'm not going to allow you to do that. My general rule of thumb, Mr. King, is if you're representing yourself, you can say whatever you want from your seat. If you stand up or you start gesturing, then we're going to intervene. Do you understand that?
Yes, sir.
You are going to be a little bit restricted if you're moving around. You're going to use this path behind Mr. Engel. You're going to go up to the podium, and you're going to use that path back. That's essentially the how you're going to make it to and from the podium. I'm not going to let you wander around the courtroom. I don't let anybody wander around the courtroom, though, Mr. King. So that's sort of the way that goes. If you're found not guilty, then you're going to go back to the institution. Nothing happens. If you are found guilty, then we are going to go forward with a sentence. Sometimes we do what we call a pre-sentence investigation. I generally don't do those in prison cases, but if you're convicted, we will talk about whether or not we should jump right into the sentence or we should do a pre-sentence report. Do you understand that?
Yes, sir.
The factors that I consider in sentencing They are the seriousness of the offense, the impact on the victim, your criminal history, and essentially I will allow you, and this is all if you're convicted, I'm not saying that you're going to be, but we don't really talk about the penalties if you're found not guilty because nothing happens. Then I'm going to essentially listen to anything that you want to tell me about why this offense is not as serious for the purposes of sentencing. Do you understand that?
Yes, sir.
I think, have we only had one other trial? You said you went to trial. Is that the only time that you've ever been to trial before?
Since 2019?
Have you ever been to trial before in a case?
Yes.
Okay. The case that you're in prison for, that was in front of a judge in Montgomery County, right?
Yes, sir.
Were there any other trials before that?
Yeah, a long time ago, back in the 70s.
Oh, okay, back in the 70s. Well, whatever happened in the 70s, we try not to put too much weight on. All right. So, Mr. King, do you think you understand your right to represent yourself?
Yes, sir.
Has anybody made any threats, promises, or representations to get you to waive your right to be represented by an attorney?
No, sir.
Do you think there is anything about our discussion today that has impacted your desire to represent yourself?
Not really. I just wanted to talk to Mr. Engel real quick to see his opinion about something,
Okay.
and then we go from there.
All right. So I will let you and Mr. Engel talk. When we come back, we're going to talk about, number one, do you want to represent yourself? And number two, do you want a jury to decide the case?
Well, since the last jury trial I had back in 2019, I would prefer to pass on the jury and just take the judge.
All right. I think, Mr. Engel, it makes more sense to do those in reverse order. So why don't you talk to Mr. King first about his right to a jury? Because if you waive your right to a jury, Mr. King, then I really worry a lot less about things like standby counsel and the rules. Because if you want to represent yourself in front of me, Mr. Engel's going to be right next to you because I don't have to worry about me being confused about standby counsel. I will understand the role of standby counsel. I'm not going to get confused about him representing you. And I also, if there's no jury, you and he can discuss matters at counsel table. So if something comes up and you say, Judge, give me a second, I want to talk to Mr. Engel about that, he just leans over and you guys have a discussion. The reason that I don't let you do that where there's a jury here is because then the jury is naturally going to assume that he's representing you, because on TV they see a guy in a tie representing a guy who is not in a tie. They're going to think that he's representing you even if I tell them not. So let's cross the jury waiver off the list first, and then we will decide whether or not I mean they're sort of entwined with one another, but why don't you guys talk and then you let me know what it is that you want to do. We will take, how's 10 minutes? Is that enough time? Let's take 10 minutes to figure this out. And I understand that the jury is in the process of checking in now.
Can we talk in here, Your Honor?
I mean, I'll clear the courtroom except for security, and as long as that Mr. King, we broadcast our proceedings to YouTube. That means that there might be people watching us. There might not be. I don't know. If that red light is on in front of you, that means there is sound on the YouTube. If that light is off, that means that the YouTubers can still see you, but they can't hear you. Do you understand that?
Yes, sir.
All right. Anything else? Let's go ahead, after we go off the record, just fix the camera on the bench. That way they can't see if anybody's watching. I don't know if they are. Okay? All right. 10 minutes, we'll clear the courtroom except for the security people so that you can talk.
Thank you, Your Honor.
Good morning once again, everybody. It's TCF Live on a Monday. Good to have you all here. So Barbara asked in the chat if we've been to this court before, and no. This is Warren County, Ohio, the Court of Common Pleas. There's actually 3 different feeds that they run for 3 different courtrooms. The reason I normally don't go there, though, is that there is no DVR capability with those courts. It's all broadcast in real time. We can't pause. We can't go back. So it's very hard for me to pick up a hearing at the beginning. If you go to this court, you just kind of get what you get. It's kind of like Judge Glazer, same thing, where if you go there, you're kind of getting in real time, but those are very short hearings, where these courtrooms tend to have longer things, so often you end up picking it up in the middle. But it was still interesting to go there this morning and listen to him give the instructions. Very thorough, very interesting, I thought. But we do need to move on, so let's go to Michigan, and we'll see what's going on with Judge Elmore this morning.
Hi, we are on the record now today for the 28th Circuit Court here in Wexford County, and we begin today's docket call by taking up the case of People of the State of Michigan versus John Burgess. This is case number 25-14157 FH. Appearances from counsel, please.
Joanna Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Burgess.
Thank you. Mr. Burgess joins us this morning via Zoom from a Michigan Department of Corrections facility in Ionia, I believe. Also here in the courtroom this morning is Miss Lindsay Simmons. She's an agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. A moment. We are here today for a sentencing after a plea. A plea was entered back on or about December 8th of 2025. I have received a copy of the pre-sentence investigation report. All right. I did not apparently catch any corrections. Let's see if the council did. Ms. Carey
No corrections.
and Mr. Harrison.
None for us either, Your Honor.
All right. Well, thank you very much. We are next at sentencing. Mr. Harrison, go right ahead, sir.
Well, this case presents a sort of an odd configuration, Your Honor, because on one hand, it's a pretty simple, straightforward case. It's a use of methamphetamine as a second or subsequent offender, a relatively low-level felony with a 2 to 17 guideline, despite Mr. Burgess's extensive criminal history. On the other hand, it's complicated because if you look at his Otis page, you will see that he was due to be released from his sentence in 2018. Obviously, that didn't happen. He's still in prison. It's parole violations, et cetera, et cetera. Right now, we believe his release date is July 26th, the upcoming July 26th, so 2026. That is consistently what Mr. Burgess and I have discussed. That is not what Otis indicates. Otis indicates a max discharge date only sometime in 2032. We don't believe that to be accurate either. So it presents something of a conundrum to the court in terms of the fact that this is a consecutive sentencing situation. The question becomes consecutive to what? If it's to his initial sentence, that's okay. He could serve it in effect concurrently with the time he's serving now due to his parole situation. If it is subsequent or consecutive to his current term that he's serving due to his violations, then it would have to be tacked on at the end. Perhaps he could even come back here and serve a little bit of jail. If you'll also notice in the report, Your Honor, this incident occurred a long time ago. He has 87 days from the time that he entered the plea in this case. I know he doesn't get day-for-day credit for that, so that's not what I'm asking. What I'd like for the court is simply to recognize that he's been there. I don't know what else to say about this. This is a sort of a silly event that occurred where he scared a bunch of people because he was in a place he shouldn't have been, making noise about wanting to talk to somebody who apparently didn't live in that neighborhood. That's what drew the police attention, rightfully so. And you can see by even a quick glance at his criminal history that he has struggled with addiction and substance use, et cetera, for most of his adult life. I think he's reached a point in his life now where he's tired of being on the revolving door. He's tired of doing life on the installment plan, and he has a better plan for his future. And he has some stuff he needs to clean up and clear up and take care of. This is the last of those things. Other than this, it's simply a matter of obtaining his ultimate release date, making some plans for the future, completing some programming in the MDLC, and moving on with his life. Thank you.
Ms. Carey, on behalf of the people, ma'am.
Thank you. What we have is Mr. Burgess, who, while on parole, got arrested in Osceola County for the aggravated indecent exposure. And a couple weeks before that, he was here in Cadillac on this case and got kicked out of the Sun and Snow Motel, walking down Sunnyside Drive, saw what he believed to be an abandoned house, went in the backyard and had his pants down, I don't know doing what, and the homeowner had video and was alerted to someone on his property, and the police called and they found meth residue on him. We had someone on parole breaking the law, not once, but twice that we know of. And this is not the last case he has to take care of. He still has to take care of the Osceola County case that sent him to prison. I think the defendant has shown that he is not supervisable. I think his recommendation for incarceration is well reasoned, and I'm going to ask the court for a sentence of incarceration. And I know the guidelines are 2 to 17, but given his behavior, his performance on parole in the past, and his lengthy criminal history, I think it's appropriate. Thank you.
All right, Mr. Burgess, you have the right to make a statement before the court issues a sentence, sir. Is there anything you wish to say at all?
No, I'm all right.
All right. Well, let's do a little walk through the defendant's criminal history, which began as an adult 30 years ago in '96. Couple assaultive issues back in '96, 2 of them going on at one time. He made it about 4 years after that. Picked up just a petty theft case. Then he had a couple year gap. Looks like about 3 years before he picked up an unlawful use of a motor vehicle. Made it 2 days after that. Oh wait, oh, he was on bond. I'm sorry, I've got that. He was on bond pending the 1 unlawful use, picked up a 2nd unlawful use. When that case was resolved, he was on probation for about 7 of his 12 months and picked up a 3rd unlawful use. So in other words, the same offense. We're starting to wonder about the defendant's ability to learn from his choices. Now in that, or after that, looks like he made it about 4 years before he picked up a case here up in Wexford. And it was just a disorderly person, which seems to be a little bit similar to what we have in today's case. After that was resolved, he made it about 10 months before picking up some other felonies. So it looks like it was resolved with a misdemeanor plea. And he violated probation within 4 months, and he did so on 1, 2, 3, 4, at least 4 different occasions over his first 10, 11 months of probation. One of those was assault and battery. Looks like after he was off of probation, he was released from probation on December. Hold on a moment. Ms. Simmons, if you could please turn to CFJ 284, page 9, looking at entry 15 of 26. The offense date was December 19th. If you flip backwards, you'll see that at the top of page 8, entry 12 of 26, his discharge from probation was 3 days thereafter.
Yes, Your Honor, my apologies. I was looking at the 12-15 one.
Yeah, I figured that. It's all right. I didn't see it earlier myself. So for entry 15 of 26, he was on probation at the time.
Okay.
That probation was terminated. Plus, 1 month later, he picked up another charge. Now here we've got disorderly conduct, surveilling an unclothed person. He had multiple probation violations in that file as well. So we have some disturbances of the peace and interruption of people's privacy living in this community. Then in 2017, while on probation, he picked up an aggravated indecent. Looks like, yeah. Well, he had a charge for indecent exposure, for which he was convicted. Possession of meth, sounding similar. He then, while I look at the narrative, while on probation, he was sent back for the aggravated indecent exposure due to violating his probation. Entry 12 of 26 occurred while on parole for the previous cases. Entry 21 of 26 also occurred on parole. Oh, by the way, entry 20 was another disorderly person. There's some more batteries. When we get to entry 22 of 26, occurred while on parole. Tampered electronic monitoring device, by the way, which is not the first time. She had another one of those previously. Let me go back and make sure I'm correct. I'm sorry, I saw malicious telecommunication use. I was wrong. So I continue. Then we pick up, or the defendant picks up the, while on parole, this particular offense, plus, well, this case was, before he got arrested on it, he picked up another case for aggravated indecent exposure in Osceola County. And again, do we have any resolution of that file?
Not to my understanding, Your Honor, no.
So we have an individual who repetitively is out there interrupting people in their neighborhoods, in their home, in their community, exposing himself, which, by the way, in this case, he was walking around with his pants down. At least he chose a day that was in the summer. I think this one was in June. Luckily, it wasn't December. But he was disturbing people. And this is one of the problems where drug cases are not a victimless crime. And now you've got an individual who's walking around naked up to people's houses in residential neighborhoods. This was out on Sunnyside Drive. Well-traveled road, of course, here in Wexford County, and obviously a residential area. So it's quite concerning to this court that the defendant continues to violate the law. That's number one. Number two, that tends to be where he's either violent, disruptive, walk around naked, peering in through windows, and involving methamphetamine or controlled substances here. So in this particular case, the court not only finds reasonable grounds for a period of confinement, we're seeing the same repetitive history, which is going to establish the proportionality and reasonableness of the sentence. The defendant has a difficulty being supervised, a difficult time complying, and a difficult time keeping his pants on. Court sentences the defendant to a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee. There are no supervision fees. There are no DNA fees. I assume DNA was already available. Okay. I see that. So now the question becomes a period of confinement. The court recognizes that the defendant has, how long has he been in custody? Hold on.
He was returned on
7/24.
Well, no, this offense occurred on June 30th of 2025. The charges were filed on October 6th, and he was arrested on October 17th. So
He'd been returned.
He was back in prison, Your Honor, on July 22nd of 25.
Oh, 25.
The Osceola incident.
I got it.
Yeah.
Into prison.
Oh, okay, the one that's still pending?
Correct.
They, parole board would use that to
Correct.
violate him, put him back in prison on his original previous felony. All right, thank you. Well, the court recognizes that any period that the court sets must be served consecutively. The defendant, again, scores an intermediate sanction cell, but there are plenty of reasonable grounds here today. The court sentences the defendant to a sentence. I'm recognizing, quite honestly, I was treating it like a prison sentence, but I also recognize that he's currently serving a prison sentence, and any sentence I give has to run consecutive, and he doesn't receive credit for that. So therefore, the court, taking all that in consideration and establishing a proportionate reasonable sentence, I sentence the defendant today to, and I'm sorry, I also have to acknowledge that I'm sentencing within the controlled second or subsequent offense double penalty, which is with the discretion of the court. I sentence accordingly, and I sentence the defendant to 270 days. He receives 0 credit, obviously because of the parole detainer. That, of course, must run consecutive to whatever sentence he is serving on the parole detainer. Have I missed anything, Ms. Simmons?
No, Your Honor. Thank you.
Have I missed anything, Ms. Carey?
No, thank you.
Mr. Harrison?
I don't believe so, Your Honor.
All right. Mr. Burgess, you will receive there at the confinement facility an advice of rights form. You should receive 2 copies. The first one you will place your initials on. Doing so neither elects or waives any rights. It merely acknowledges receipt of your copy of the document. This document will tell you that you have the right to appeal the conviction and sentence in your case, and where that is typically done by filing a claim of right to appeal. Based upon the plea, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of this document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Now, today, everything I've said, I think, is pretty straightforward. Mr. Burgess, I hope that some of the things that Mr. Harrison said on your behalf are true, that you are tired of living life on this installment plan of sorts. You've been doing it now for 30 years. That's a long time. Really hope that you are seeking treatment there at the facilities. I hope that you are benefiting from it. And next time you get out, I hope that you seek treatment outside as well. You need to be attending AA or NA or some kind of program, or maybe speaking with community mental health, because you are presenting yourself to be a disruption to the community. You're also putting your health and life at risk. Thank you. We're adjourned.
So Judge Elmore recommended Alcoholics Anonymous for him. I wonder if they have a Dropping Your Pants Anonymous, because it sounds like that's closer to what he needs. Another stunning human being here on TCF. Good morning, everybody. Happy Monday to you. Reminder, we have a fourth hour starting today. The fourth hour will be different from the other three. It'll be a little more discussion-based. If you are a channel member, you have the ability to join me on stage. You need to go to Discord. You will find it in the channel member announcements. There's a link every day that will be posted there for you to be able to join if you want to. So I encourage you to do that. Hop on stage with me, discuss what we saw during the day or anything else that I'm covering in that fourth hour. It'll be fun. Okie dokie, let's go to Florida. Wade Mercer is just starting his first appearances.
Case, we do have Mr. Ricardo. Good morning, Mr. Ricardo. First case, Mr. Ricardo, I'm not sure which case you're here on, actually. Can you tell me?
Yes, Your Honor. I was requested for Javier Sobrino.
Okay, Javier Sobrino. Mr. Ricardo, if you'd please introduce yourself to Mr. Sobrino and make sure that he can see and hear you.
Señor Sobrino, mi nombre es Jordani Ricardo. Soy intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
Perfect. Mr. Sobrino, you here because you've been charged with one count of driving with no valid driver's license?
Señor Sobrino está aquí porque tiene un cargo de manejar sin licencia de conducir válida.
Mr. Sobrino, I have read the complaint and there is probable cause for the charge.
Señor Sobrino, leí la denuncia y hay causa probable para el cargo.
Mr. Sobrino, you're entitled to a bond as far as I can tell in this case.
Señor Sobrino, hasta lo que yo puedo identificar en este caso, usted tiene derecho a una fianza.
But your criminal history does reflect a prior issue with immigration about 2 years ago.
Pero sus antecedentes muestran que tuvo una situación con inmigración hace como unos 2 años.
So I'm going to ask the jail first, have we heard anything from immigration in Mr. Sobrino's case, Sarge?
I've not gotten a response yet. I notified them this morning, but no response yet.
Primero le voy a preguntar a la cárcel. Hemos escuchado de parte de inmigración en cuanto al señor Sobrino. Todavía no hemos escuchado de parte de ellos. Esta mañana les notificamos, pero todavía no nos han respondido.
So, Mr. Sobrino, your first option is for me to set you a bond this morning.
Señor Sobrino, la primera opción que tiene es que yo le fije una fianza esta mañana.
If I set you a bond, your bond will be $2,500 cash or surety.
Si le fijo una fianza, la fianza serían $2,500 en efectivo o mediante un bono de seguridad.
And you would be able to post that as of noon today.
Y podría pagarla a partir del mediodía de hoy.
What that means is if the United States Immigration Service chose to place a detainer on you before noon today, Central Time, we would have to honor that.
Eso significa que si el Servicio de Inmigración de Estados Unidos decide darle una orden de retención antes del mediodía de hoy, hora del centro, nosotros tendríamos que cumplir con eso.
Your second option is if you would like to resolve the case, I'm going to make you the following plea offer subject to the state's approval.
La segunda opción, si usted desea resolver su caso, le voy a ofrecer el siguiente acuerdo que queda sujeto a la aprobación del Estado.
Mr. Mitchell, any objection to the plea offer that was in the text this morning?
Go ahead, Mr. Ricardo.
Señor Mitchell, ¿alguna objeción al acuerdo que se ofreció y se envió mediante texto esta mañana?
¿Cómo que no lo entendí? I did have a question regarding it, and I don't know if I missed a typo or something.
Responde el Estado, tengo una pregunta, no sé si fue que malentendí algo.
Was it 10 days jail with a $400 purge?
Yes.
Okay, I read it as a 10 days with the fine. That's what I read it as.
Son 10 días, lo que se le ofrece son 10 días en la cárcel con $400 de purga. Sí, señor. Y bueno, lo había entendido diferente.
So if you wish to plead guilty or no contest and resolve the case, you can do that also.
Entonces, señor, si desea resolver el caso declarándose culpable o no me opongo, puede.
If you enter a plea of guilty or no contest, you'd be sentenced to 10 days in the Jackson County Jail.
Si se declara culpable o no me opongo, se le condenaría a 10 días en la cárcel del condado Jackson.
But you would be able to be released by paying a purge of $400.
Pero pudiera quedar en libertad pagando una purga de $400.
And the case would be over.
Y el caso terminaría.
Similar to the bond, though, you would not be released until noon today.
Similar a lo de la fianza, no se le dejaría salir hasta el mediodía de hoy.
So you get to pick whether you would like to post the bond and come back to a later court date,
Entonces usted puede decidir si desea pagar una fianza y regresar en el futuro a otra audiencia,
or enter a plea of guilty or no contest, in which case I would sentence you to 10 days in jail with a $400 purge.
o declararse culpable y no me opongo, y en ese caso yo lo condenaría a 10 días en la cárcel con una purga de $400.
Do you have any questions about that option?
¿Tiene alguna pregunta acerca de esa opción?
Sí.
Yes.
Okay.
Bien.
Son 10 días en la cárcel y $400, o si pago los $400 saco.
So 10 days in jail and $400, or if I pay the $400, I'm released?
If you pay the $400, you're released from our hold.
Si paga los $400, se le deja salir de la detención nuestra.
So let's say that you enter the plea and you pay the $400, you'll be released at noon.
Así que digamos que usted acepta el acuerdo y paga los $400, se le dejaría salir al mediodía.
But only if the Immigration Service has not placed a detainer on you at that point.
Pero solamente si para entonces inmigración no le ha dado una orden de retención.
I have no idea if they will or not. I just see that they've been involved in your life before, it appears.
No sé si darán esa orden o no. Sencillamente veo que ellos han estado envueltos en su vida anteriormente, según parece.
Do you have any other questions?
¿Tiene alguna otra pregunta?
No.
No.
So do you prefer the bond, or would you rather enter a plea of guilty or no contest?
¿Prefiere la fianza o prefiere declararse culpable o no me opongo?
No me opongo.
No contest.
You do need to understand, if you enter a plea of guilty or no contest, you're waiving your right to a trial.
Debe entender que al declararse o culpable o no me opongo, está renunciando a su derecho a un juicio.
And you're also waiving your right to call and cross-examine witnesses at that trial.
Y también está renunciando a su derecho a llamar y contraexaminar testigos en dicho juicio.
Mr. Brunner, are there any other things you want to make him aware of before he enters a plea?
No, sir, Your Honor. Mr. McDaniel had met with him and he had indicated he wished to take plea.
Ay, señor Brunner, ¿hay algo más de lo cual usted quiera ponerlo al tanto antes de que él acepte el acuerdo? No, señor, él se reunió con el señor McDaniel esta mañana e indicó que deseaba aceptar un acuerdo.
So, Mr. Sobrino, knowing all of that, is this the plea of no contest? Is that what you wish to do?
Entonces, señor Sobrino, sabiendo todo eso, declararse no me opongo es lo que usted desea hacer?
Sí.
Yes.
I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir válida.
I'm going to withhold adjudication of guilt and sentence you to 10 days in the Jackson County Jail.
Le suspendo el fallo de culpabilidad y lo condeno a 10 días en la cárcel del condado Jackson.
But you can purge that sentence and be released on this charge at any point before completing it.
Pero puede purgar la sentencia y quedar en libertad de este cargo en cualquier momento antes de completar la sentencia,
By paying the court costs and fine amount of $400.
al pagar la cantidad de multas y costas del tribunal de $400.
Mr. Sobrino, as I've said, you will not be released until noon today, even if you paid the court costs and fines.
Señor Sobrino, como ya le dije, no quedará en libertad hasta el mediodía de hoy, incluso si paga las multas y costas.
Lastly, court costs and fine purges are paid at the clerk of court's office, not at the jail.
Finalmente, las purgas de multas y costas del tribunal se pagan en la oficina de la Secretaría Judicial, no en la cárcel.
They have to be paid while the clerk's office is open, which is 8 a.m. to 4:30 p.m. Central Time.
Y tiene que pagarse mientras esa oficina de la Secretaría Judicial está abierta, que es entre las 8 de la mañana y las 4:30 de la tarde, hora del centro.
So, Mr. Sobrino, you'll be able to use the phone in just a few minutes to contact friends or family to try to make that purge.
Entonces, señor Sobrino, en solo unos minutos se le permitirá usar el teléfono para llamar a familiares y amigos y tratar de pagar la purga.
They can make it in person or they can make it over the phone with a credit or debit card if they wish.
La pueden pagar en persona o pueden pagar por teléfono con una tarjeta de crédito o débito, si así lo desean.
If you want to make the purge out of your own money that you have at the jail will talk to you about the process to do that.
Si usted desea pagar la purga con su propio dinero que usted tenga en la cárcel le hablarán de cómo hacerlo.
Do you have any questions?
¿Tiene alguna pregunta?
Sí.
Yes.
So the clerk's question is, what happens if, Mr. Mitchell, if the Immigration Service places a detainer, if they do place a detainer on him at noon, what is the state's position going to be on a time served offer at that point?
I was just about to suggest that as you were saying it, I wouldn't object to it.
Señor Mitchell, si el Servicio de Inmigración de Estados Unidos da una orden de retención para el mediodía de hoy, ¿alguna objeción a que se le ofrezca tiempo ya cumplido? Responde el Estado, precisamente eso iba a sugerir yo, no tengo ninguna objeción.
So, Mr. Sobrino, you need to get your friends or family to be prepared to post that purge shortly, but right at noon, at 12 o'clock noon.
Señor Sobrino, entonces debe preparar a sus familiares y amigos para que paguen la purga, pero justo después del mediodía.
And if the jail tells you there is an immigration hold and you know that you're not going to be released, then my suggestion is do not post the purge.
Si la cárcel le notifica que tiene una orden de retención, que no lo van a dejar salir, entonces mi sugerencia es que no pague la purga.
Because if the immigration does place a hold on you, Mr. Mitchell's offer probably is going to be time served tomorrow and just go, and that'll save you the $400.
Porque si usted, si inmigración le da la orden de retención, entonces mañana el señor Mitchell le ofrecería probablemente tiempo ya cumplido, se iría con ellos y eso le ahorraría los $400.
Because if immigration is going to detain you, then you need to deal with that more so than this minor offense.
Porque si inmigración le da una orden de retención, pues tiene que lidiar con eso en vez de con esta ofensa menor.
Do you have any questions?
¿Tiene alguna pregunta?
Sí.
Yes.
Okay.
Bien.
¿Cómo lo puedo pagar yo desde aquí, del dinero que tengo aquí?
So how can I pay it with the money that I have right here?
Do you have $400 in cash or is it in some other form?
¿Usted tiene los $400 en efectivo o los tiene en alguna otra forma?
En efectivo.
Cash.
Okay. Sarge, I know there's a booking fee that comes out of his cash property. Is that correct?
Yes, sir.
Sargento, sé que hay un costo relacionado con pagar con su propiedad, ¿no? ¿Es correcto? Así es, señor.
How much?
¿Cuánto?
25.
25.
I couldn't hear. Did he say 25?
Yes.
Y no escuché, dijo 25. Sí, señor.
So, Mr. Sobrino, do you have at least $425 in cash?
Señor Sobrino, ¿tiene por lo menos $425 en efectivo?
Yeah.
So what I'm going to do is, if the Immigration Service has not placed a detainer on him by noon, Sergeant,
Entonces, sargento, lo que voy a hacer es, si el Servicio de Inmigración de Estados Unidos no le ha dado una orden de retención para el mediodía,
can y'all bring him to the courthouse with the $400 in cash so that he can post the purge?
Yes, sir.
¿pueden ustedes llevarlo al tribunal con los $425 en efectivo para que él pague la purga? Sí, señor.
If Immigration has placed a detainer on him by noon, I will just see him tomorrow morning.
Si Inmigración le ha dado una orden de retención para el mediodía, sencillamente lo vería mañana por la mañana.
Thank you, Sarge. Any other questions, Mr. Sobrino?
Y gracias, sargento. ¿Alguna otra pregunta, señor Sobrino?
No.
No.
Have a good day, sir.
Que tenga buen día, señor.
Thank you, Mr. Carter.
Thank you, Your Honor.
Ladies and gentlemen, we do have a couple friends or family here, so let me call those cases next. I've got the names a couple different ways on this next case. I've got Harrison Vargas, and then I have Harrison Velez Vargas, and the complaint says Harrison Velez. So I'm not sure which of those is accurate.
What's your last name?
So what is your correct name?
First name Harrison, last name Velez. Velez Vargas is both the last names. First and second last name.
Okay, so Velez would be your mother's maiden name, is that correct?
That Vargas. That would be Vargas. Velez is my paternal last name.
Okay, so you prefer to go by Mr. Velez, correct?
Yes, sir.
Okay, Jasmine is in the courtroom here. I want you to let you know she's here on your behalf. You're accused of one count of driving license suspended or revoked with knowledge. Mr. Velez, I'm going to appoint the public defender's officer to represent you, tell you there is probable cause in the complaint. I have read your criminal history. Listen to Mr. Blunt, your attorney for today's purposes, and we'll see where we stand.
Your Honor,
Okay.
it's my understanding Mr. Harrison Velez Vargas would like to enter a plea of no contest with the understanding, subject to your approval, he'd be sentenced to 10 days in the county jail with a purge of, is it 400? Is that what y'all, $400 fine? And that can be paid. Once it's paid, he would be released from jail. He would receive 1 day credit for this.
Mr. Mitchell, any objection to that?
No objection. That is agreeable with the state.
Sir, did you hear that agreement?
Yes, sir.
Do you have any questions about that agreement?
No, not at all.
And is that the plea you would like to enter?
Yes.
Okay, to the young lady in the courtroom, are you going to be the one making the purge for him? No? Okay, so whoever makes the purge, she doesn't know if she will or not. Whoever makes the purge for you, make sure they understand that it's got to be made when the clerk's office is open. The reason I tell people that is I don't want somebody trying to make a purge at 5 o'clock today. The clerk's office is closed. You've got to spend another night in jail before you can get out tomorrow. So make sure they go ahead and make it before 4:30 when the clerk's office closes. I would tell them before 4 o'clock. If I'm in jail, I'm gonna tell them go ahead and make it now. Just be aware of that. Any questions before I accept this plea?
No, not at all.
I'm gonna accept your plea of no contest to the charge of driving license suspended or revoked. I'm going to withhold adjudication of guilt. I'm gonna sentence you to 10 days in jail, but you can make a purge on that sentence and be released immediately before finishing the 10-day sentence by paying court costs and fines of $400. If you make that payment at the clerk's office when they're open, you're gonna be released. So if the payment's made this morning, they will notify the jail by secure email that the purge has been made and you'll be released. If the payment's made in person, the clerk's office will get a receipt. Whoever makes the payment, they'll take that receipt to the jail and you'll be released. And if you can't make it for 2 days, then whenever you do make it, you'll be released at that point. Any questions, sir?
No, not at all.
All right, have a good day. Ma'am, do you
Thank
have
you.
any questions? Any questions, ma'am? All right. Next case that has friends or family here, ma'am. I can't hear you. Do you need you need a what to get him out?
I'm from another state. I'm not sure if I need a license.
All you need is a receipt showing that purge has been made. So if you or someone's going to make that purge, they make it at the clerk's office, either in person or by phone. If it's made by phone with a credit or debit card, the clerk's office will send an email to the jail that it's been paid and he can be released. If it's made in person, they will give you or whoever makes it, they'll give them a receipt showing it's been paid. Then you take that receipt to the jail and he'll be released. So as soon as it's paid, he'll be released. You don't have to worry about a license unless you pay it in person with a card. They may ask you to verify your identity that you're the person that has that card, but otherwise you don't have to have a license. The clerk's office is downstairs on the first floor on the east side of the courthouse. So you go out this door, Deputy Spates is in the back. He can show you where it's at. Okay. Hey, ma'am, this paperwork here, are you going to try to go down there and try to pay it?
Get information if I can.
Okay, this is his disposition. It's got the amount on it. Next case, it has friends or family here is Desmond Baker.
Baker.
Mr. Baker, good morning. Mr. Baker is very tall. Sarge, we're going to need to address that camera up, please. We can see Mr. Baker. There we go. Mr. Baker, good morning. You're here because you've been accused of one count of aggravated battery. Mr. Baker, there is probable cause in the complaint. Mr. Baker, I have read the complaint. I've also looked at your criminal history, and it appears to me that you're out on bond in case 25437. Is Mr. Mitchell, is that what you show?
That's what I showed too.
So, Mr. Baker, even though I think you're entitled to a bond, you very well may be held without bond. In that case, the other case, we're going to see what happens in just a moment. Mr. Mitchell, anything from the state?
I have been provided information from his stepfather regarding both the bond situation and this new case, if you're okay with me saying that.
And I apologize. I meant to tell you your stepfather's in the courtroom and I forgot. Go ahead, Mr.
So according to my conversation with his stepfather, they have already been in contact with the bondsman about keeping him on bond. Additionally, I was provided a sheet of paper by the alleged victim in this case, and I believe our victim advocate has also been in contact with the victim, talking about how, you know, she may be wanting to have these charges dismissed. I know that he's charged with a second-degree aggravated battery, and this happened after he was on bond. So we'll just leave it up to the court to determine whether or not his bond should be revoked in 25437 CF, given those circumstances.
Thank you. Mr. Blunt.
I did have the opportunity to, when his stepfather came in, he had a letter that was signed by the alleged victim. It was addressed to Mr. Larry Bassford in his office, but based on the situation, I did read the complaint. Your Honor, I would ask that the court allow him, set him a reasonable bond on this with the understanding that the victim is not wanting to pursue charges, and allow him to remain on bond in the 23 case number.
Okay. So, Mr. Baker, the complaint alleges she told law enforcement you hit her with a 2x4 at least twice. So the question is, are there any injuries to support that? And I'm going to read from the complaint here. She advised that Desmond Baker pushed her to the ground. Victoria then stood back up and kicked over a cooler door, being upset. Victoria further stated that Desmond Baker continued to escalate the incident by grabbing a 2x4 wooden board and striking her once in the abdomen and once on the left side of her head. Photographs were taken of Victoria Hewitt's injuries, which are consistent with her account of a physical altercation. So since there appears to be injuries consistent with the account, then I'm going to revoke your bond. It's a no-brainer to me. You're accused of a second-degree felony while you're already on bond. So I'm going to set your bond in the new case. Don't get confused, though. Even though you're getting a bond in the new case, $15,000, don't try to post it, because I'm revoking your bond in the case you're already out on bond on. I think it was a drug offense, and it's pretty recent. He's on bond in 25437, and in that case, I don't know why I'm thinking it was cocaine charge, because it was. Possession of cocaine and principal destruction or tampering with witness. So in 25437, I'm revoking your bond. This is not the bonding agency's choice. They have no input at all in this. The question is, have you committed a crime while you're on bond, or is there evidence you've committed a crime? And is that evidence concerning enough to a judge to revoke your bond? And it is. So you have no bond in that other case. Now, let me tell you what happens. The state attorney's office will get the new case, Mr. Baker. If they decide they're going to dismiss that new case, Judge Garcia very well may say, hey, since they're dismissing the new case, I'm going to reinstate your bond. That may happen. But right now, considering the allegations against you and the evidence against you, you've got no bond in the case you're already out on bond on. Mr. Baker, do you have any questions?
No, sir.
Sir, do you have any questions in the courtroom? Any questions? Any questions? Wish you the best, Mr. Baker.
Your Honor.
We do need to give you a court date for Judge Garcia, and that would be February 3rd. February 3rd at 8:30 would be his court date, please.
Do you need a proposed order?
Yes.
Okay.
Yes. I need an order unless the state is deciding to drop the charges today. If y'all look, I don't know that you'll even have it.
Yeah, it's too early.
I would think it'd be too quick. So
Yeah.
if y'all need time to look at it, send me an order revoking his bond, and then once y'all make y'all's charging decision, we'll go from there.
Okay.
All right. So wish you the best, Mr. Baker.
Thank you.
That takes care of everyone that has friends or family in the courtroom. And guess what? 15,000. And the condition, no contact with alleged victim. Mr. Baker, you've got a condition of no contact with alleged victim. Sarge, please make sure he knows that's a condition that's required by law. At least.
Yes, sir. He's right here.
Thank you. So that takes care of everybody that has friends or family here, I believe. Let's go back to the top of the docket. I know I have a 9 o'clock hearing, Mr. Green, Mr. Axon, but we have a bunch of first appearances, so we'll get to it as soon as we can. Samuel Mills is next. Mr. Mills, good morning. You're here because you've been accused of 1 count of grand theft motor vehicle. Mr. Mills, there is probable cause for the charge. I've also looked at your criminal history, and I think you're entitled to a bond as far as I can tell. Let's see if the attorneys have any additional information. Mr. Mills, Mr. Mitchell.
No, Your Honor.
Mr. Blunt?
No, sir.
Mr. Mills, your bond's going to be $5,000 cash or surety. It's a standard bond on this charge, sir, for someone that has criminal history at least. You've got a condition of no contact with alleged victim. So you cannot have no contact with alleged victim, but you do get to use the phone to try to post the bond. Cash or surety means you can put up all of it if you wish, or you can go through a bondsman. Mr. Mills, do you have any questions?
No, sir.
Mr. Mills, you're going to also be given a notice for your court date, which will be February 3rd. And I wish you the best. You'll get to use the phone shortly, sir.
Thank you, sir.
Yes, sir. We have Keon Hamilton. Mr. Hamilton, good morning. Mr. Hamilton, you're here because you've been accused of 1 count of misdemeanor domestic violence battery. Mr. Hamilton, there is probable cause in the complaint. You have 1 prior charge on your criminal history, but it's not the type of charge that would prevent me necessarily from giving you a conditional release if you have somewhere to go and live other than where the alleged victim lives.
Yes,
So
sir.
the alleged victim's relationship to you, the person that's accused you of this, is what relationship to you?
It would be my sister, correct? I'm not sure.
I'm not sure if it mentions niece, it mentions siblings. I'm really sure the person that claims that you threw water on them is a sister. Is that right?
Yes, sir.
Now, you and that
Yes, sir.
person live in the same home.
Yes, sir. But I can leave. I can move. Yes, sir.
Where else would you go then? Where else
My
could you go
friend-
on a temporary basis?
My temporary, I could go to my great grandmother's house.
Is that in
like
Jackson
today.
County?
Yes, sir.
Okay, Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. Blunt?
I'd ask for a conditional release, Your Honor.
Mr. Hamilton, I'm gonna let you pick between the bond and the conditional release. If I offer a conditional release, I always give a bond option just because some people prefer a bond. Your bond will be $2,500 on this misdemeanor charge. I am going to offer you a conditional release because of the allegations and your history. You do have a condition, no contact with the alleged victim, at least for the time being, which means you can't live in the home she's living in. Mr. Hamilton, do you know whether you prefer the bond or the conditional release?
Sorry, what exactly is conditional release?
Did Mr. McDaniel meet with you this morning?
Mr. McDaniel?
The attorney, the assistant public defender?
He said he didn't want to talk to me.
Okay, so let me tell you what a conditional release is. A conditional release, well, let me explain a bond so you can compare the two. A bond is where you go through a bondsman or put up all the money. So in your case, it's $2,500. You either put up $2,500 or you go through a bondsman and they'll charge you a percentage of the bond to get you out of jail. That percentage is usually around 10%. In your case, that's $250. You do not get that back. If you go through a bondsman, that's the fee for their services. They have to vouch for your appearance. If you miss court, they have to pay the whole $2,500. That's how the bond works. A conditional release is different. A conditional release doesn't cost you any money to get out of jail, but there's a trade-off. The trade-off is a conditional release has more rules to follow than a bond. That's why that's the trade-off. It's cheaper, but it's harder to live by. So on a bond, you have 3 rules. In your case, don't miss any court dates, don't be charged with any new crimes, and have no contact with the alleged victim. On a conditional release, you have those same 3 rules, plus you have other rules. On a conditional release, you have to report into a conditional release officer once a week by phone. On a conditional release, you cannot possess or consume alcohol. On a conditional release, you can be drug tested. So conditional release has more rules than a bond has, and a conditional release is not free. It costs $40, $30 a month. So it's cheaper usually because you're not on conditional release. Usually in Jackson County, 1, 2, 3 months or so is usually the average. So it's usually cheaper so that you can choose the bond and it costs you more money up front to get out of jail, or the conditional release, which has more rules to follow. Any questions?
No, sir. I'll take conditional release.
We'll grant you the conditional release. They're going to let you use the phone before you leave the jail. Mr. Hamilton, you can tell your friends or family they can pick you up at the conditional release office, which is at the Jackson County Courthouse, inside the county judge's office, and you'll probably be there in 30 to 45 minutes to be picked up. Once the conditional release officer meets with you, you'll be free to go, okay?
Thank you, Your Honor.
Yes, sir. I wish you the best. Also, going to give you a notice for your court date when you get here, and that will be February 2nd at 9 a.m. Wish you the best, sir.
Thank you.
Let me see. Freddie Jones, Justin Arnold, Adam Billiot, and Joshua Caraway. Freddie Jones, Justin Arnold, Adam Billiot, and Joshua Caraway. I'm seeing at the same time because your cases are identical for first appearance purposes at least. Which one of you gentlemen is Freddie Jones? Mr. Jones, just raise your hand. I just want to make sure I got you. Mr. Jones, you're good right there. And which one of you is Mr. Arnold? We're perfect. Mr. Billiot. And that means Mr. Caraway is left. So each of you are accused of violation of your state probation or your state supervision. In each of your cases, the circuit judge has signed a no bond warrant. So what I'm going to do is I'm going to go ahead and get you a rein and get you a lawyer appointed today if that's what you're wanting. And then we're going to see if you have any questions after we do that. Mr. Jones, do you want to have an attorney appointed to represent you?
Yes, sir.
Mr. Arnold, same question?
Yes.
Mr. Billiot, same question?
Yes.
Mr. Caraway, same question?
Yes.
All right, I'm going to appoint the Public Defender's Office of the 14th Circuit to represent all 4 of you. Listen to Mr. Blunt. He's going to give you some information, and then I'll see if you have any questions.
Your Honor, and Freddie Jones, case number 25415. Justin Arnold, case numbers 24246 and 24636. Mr. Adam Billiot's case number 25162 and Joshua Caraway 21645 CF. And all of those cases, we had not received the affidavit, waive formal reading, enter denials to the allegation they violate the terms and conditions of the probation and set them for a probation pretrial at the court. I don't know the date off the top of my head.
February 5th.
February 5th.
February 5th will be your court date, gentlemen, and Mr. Green will come see you at the jail before your court date. So your attorney will see you before that court date. Let me see if any of you have any questions. Mr. Jones, do you have any questions?
No, sir.
All right, sir. Wish you the best. Mr. Arnold, any questions?
No, sir.
Wish you the best, sir. Mr. Billiot, any questions?
No, sir.
All right, sir. Wish you the best. And Mr. Caraway, any questions?
No, sir.
All right, sir. Wish you the best. That brings us to, we've got a couple more cases. Travis Hayes.
I need to inquire of him just to make sure.
Mr. Hayes, good morning. Mr. Hayes, you're here for 1 charge of disorderly conduct and 1 charge of trespass after warning. You were set a bond this weekend. You were brought back up to try to see if we could reach a plea agreement, and we don't know the results of your conversations with Mr. Blunt, Mr. McDaniel. Is your preference to just try to post the bond? Is your preference to accept the offer made to you this morning?
The offer was 9 months, correct?
That's correct. Yes, sir.
I'll just take the 9 months.
So listen, Mr. Blunt, we're going to make sure you don't have any questions and see if this is what you want to do. Mr. Blunt.
Your Honor, on behalf of Mr. Hayes, he withdraw any previously entered pleas of not guilty and or plea of no contest, charge of trespass after warning, a first-degree felony punishable up to a year in the county jail and $1,000 fine. Disorderly conduct, a second-degree, I said felony, didn't I? I'm a little
Mr.
out of
Blunt's
practice.
normally in felony court. He's just covered for Mr. McDaniel. So this is not a first-degree felony. It's a first-degree misdemeanor.
I'm used to all mine being first-degree felonies. First-degree misdemeanor, that is nice to say. It's even better to say disorderly conduct, a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. With state subject to court's approval is that Mr. Hayes be sentenced to 9 months as to the trespass and 60 days as to the disorderly conduct run concurrent for a total of 9 months, be given credit for 2 days. Court costs and fines apply. However, ask the court to allow him, if he qualifies, to work those off at the jail and receive extra gain time.
Thank you, Mr. Blunt. Mr. Mitchell.
That is agreeable with the state, Your Honor.
And Mr. Hayes, is that the plea you would like to enter, sir?
Yes, Your Honor.
Mr. Hayes, I'm going to accept your plea of no contest of those charges. The disorderly conduct sentence will be the maximum I can give you for that charge, which is 60 days in jail, but it's concurrent, which means running at the same time with the sentence in the trespass, and that sentence is 9 months in jail. So you're actually going to finish the disorderly conduct sentence first, but they're both running at the same time. You have a total sentence of 9 months in jail, 2 days credit, court costs and fines of $370. Certainly have no problem with you getting in the trustee program. The jail will talk to you about that, Mr. Hayes. And if you get in that program, I think you did a 6-month sentence before. Did you do the trustee program before?
Once, Your Honor, a long time ago.
Okay, so you know how it works then. Mr. Hayes, if you get in that program, follow the jail's rules. Florida law entitles you to quite a bit of extra gain time. Mr. Hayes, I wish you the best. Do you have any questions?
No, Your Honor.
Wish you the best, sir.
All right.
We have James Harris.
Your Honor, notes indicate on Mr. Harris that he was returned to his cell. His offer was 3 months in the county jail for the DUI, credit for 3 days. However, I think negotiations broke down between he and Mr. McDaniel.
Okay, so he's not in the first appearance room, right, Sarge?
No, sir, and he's already had a bond set, so he just.
Perfect. Derek Pittman, last case. Mr. Pittman, good morning. Mr. Pittman, you're here on case 24-744MM. I think all we're doing today is trying to make sure your credit is correct. Mr. Pittman, it appears you were sentenced to a year in jail. I'll let you go to CREMO, inpatient drug treatment. You stayed a very, very short period of time there and left, and we've had a warrant out for you now for 7 months, more or less. So all we're doing today, you've already been sentenced, you've already pled, this case is over. I just want to make sure we got your credit right. And Mr. Blunt, what number do you have on that?
Your Honor, I have 20 days credit.
Mr. Mitchell?
That's what I'm fine with. We'll stipulate to that. If he shows 22, that's fine with me.
Mr. Pittman, did you say something, sir?
Yes, I just did. I just sat in all the county jail for 90 days in Panama City.
Yeah, you had a
I
charge
can't get
down
that
there,
credit.
though. You don't get credit for a charge down there. That's a separate matter. Now, what you do get credit for is from when you finish that hold there. If it took us a week or 2 weeks to come get you, you will get credit for that. And your attorney, Mr. McDaniel, is the one that calculated the 20 days. Does that 20 days sound right to you, knowing that's those parameters?
I think I did like 5 extra days just waiting for y'all. I did like 20 days prior to this case, you know what I'm saying? Sitting in here.
So let's look at Mr. McDaniel's email this morning.
Yes, sir.
I want to give you credit for what you're entitled to. Mr. McDaniel's email says at that point he wasn't sure if it was. Well, it's not letting me open it for some reason.
Sergeant Gross, what do you have on the prior?
I have, he was here
12
9 days. He was here 9
days.
days before he went to Chrome.
Yeah, what they're saying is that what Mr. McDaniel's email says is you have 7 more from Bay County. You had 13, then you had 7 more. So he's come up with 20. You okay with 20? If you find out that's not right, then obviously we're going to make sure we get it right. But right now we're going to give you credit for 20 because that looks like the correct number. as was explained to you at the time you pled, you're not entitled to getting additional time under the trustee system anymore because you were there on a jail release. But Florida law still allows you up to 5 days gain time per month for good behavior. So normally some people can get 10 days a month. You can still get 5 under Florida law as long as you follow the jail rules. So there's an incentive there to do what you're supposed to do out there. And under Florida law, you may get up to 5 days a month good behavior. Mr. Pittman, I wish you the best, sir.
All right.
And Sarge, that's everything I had on my first appearance list. Did I miss anything?
Well, I just want, Joshua Caraway, he had a detainer, he's got a hold from Calhoun County. I just wanted you to put that on record.
It's not
So
on the
he
first
did.
appearance sheet.
Yeah, I don't think it was on there. I seen it after the paperwork was sent up. I think I sent a copy of the detainer though.
In the first appearance package, you think there's one?
I thought I did send a copy of it, I believe.
And there
Just
may
like-
be, if it's a VOP, other than
Yeah,
reading
it's
the. Okay, so there is a detainer, Mr. Caraway, just so you're aware of it. The Bay County Sheriff's Department has placed a detainer on you saying that Calhoun County won't shoot. So just be aware of that. I'll tell you what, it won't take 30 seconds. Let's see if the Calhoun County charge has a bond on it, Mr. Caraway. And I can try to tell you that real quickly. So you'll at least know that much, unless you already know. Do you already know if it has a bond or not?
Is it a VOP there? He says it's a VOP there, so it's.
Usually they don't have a bond out of most of the counties in our circuit. And the VOP warrant in Calhoun County is 21-266 CF. It's probably Judge Young.
It is.
And that VOP warrant is opening right now on my computer. If everything works like it's supposed to, no bond. So you do have, the VOP warrant out of Calhoun County does have no bond. Mr. Caraway, any questions?
I was just hoping to see maybe if I can, whenever I go to court here, that I can be taking care of the Calhoun case from Jackson County also.
Talk to your attorney about that. Sometimes that's happens. It can happen. I won't say it's common, but it can happen. Talk to your attorney about it, okay?
Your Honor,
Thank you.
I will say this is probably going to be my case, so I'll be in contact with ASA over in Calhoun County and see if we could possibly get a global plea worked out.
All right.
All right, thank you.
Mr. Caraway. All right, Mr. Mitchell, that's everything I had on my docket. Anything else in the first appearance docket?
That's all I have, Your Honor.
Mr. Blunt?
Thank y'all for having me back.
Sarge, anything else from the jail?
No, sir.
Thank you. We appreciate it, and we'll see you tomorrow.
It's TCF Live on a Monday where we're discussing time zones in the chat right now. Personally, I believe the country should have one time zone. We can call it Freedom Standard Time or Merca Standard Time or something like that. I think we should unify. I think it would bring the country together. I don't know. When I wake up, it's dark out anyway, so it really doesn't matter to me when the sun's up. And we're kind of a 24-hour world now, so why not? Just my thoughts. Let me know what you think in the chat. Let's go to Texas, the Judge West Fashion Show.
Who'd you talk to? You did not talk to Raquel West because that's me.
I'm sorry. I'm discombobulated right now.
So did you write it down somewhere? Uh-huh.
I got it on my phone, but I don't have my phone. It's like Brittany Holmes and Crenshaw and Lane Walker.
Okay.
I talked to a couple of more too that I can't really remember their name.
All right. So did you go visit with them or did you just talk to them on the phone?
About their price ranges and stuff.
Are you working?
Yes, now I'm trying to.
You're trying to work or you are working?
The job that I work is not like constant, but I do have a little interview today. I'm trying to get to.
Where's that?
It is retirement home on my something on college.
Called what?
I don't know the name of it fully. My sister got me an interview there.
Okay.
It's a retirement home on College Street for maintenance.
Okay.
Cleaning.
So where are you working a little right now?
On the protocol, my only when I can go.
Okay. Let's see. So you've been coming now for several months. Second. Let me check something. All right, so what I'm going to do, Mr. Eli, is reset your case one more time. You need to try to get someone hired before that next court date. If not, you need to visit with at least 3 others. You can tell by talking to them, they all charge different amounts and have different payment plans and things like that. You need to bring me that information, write it down, bring me who you've talked to, how much they charge, if you've gone in person, if you're just calling. I want you to actually try to get somebody hired, okay? All right, step in front of the clerk. Sign right. Isaiah Tyson. Good morning, sir. You're Isaiah Tyson. And Mr. Tyson, were you able to get someone hired? Who'd you talk to?
I talked to Lord Razzo, I talked to Kent Johns, I talked to Corey Crenshaw, I talked to Whitney Holmes.
Okay, good. Are you working?
I received this.
You do? So, Mr. Tyson, you qualify for a court-appointed lawyer. I can get you taken care of this morning. Is that what you want to do?
Yes,
All right, if you'll step in front of the clerk, she might need you to sit for a few minutes and wait, or she might have that information. Okay, have a step right here and she'll let you know who that's going to be. It is in its home, but that's because you just wanted one more. Kevin Kelly's. Good morning, you're Kevin Calise. And Mr. Calise, were you able to get someone hired? All right, did you talk to some lawyers? Speak up, please.
I talked to Joe Vasquez, Kelly, and James.
Okay,
And also,
okay. And where are you on being able to get someone hired?
I'm about to say
I'm sorry. Y'all, I can't hear. I'm having a hard time hearing. So if I can get you all to please keep it down. Say it again.
I'm about to switch jobs because the job that I have right now is barely giving me any hours.
Okay.
Maybe in about a month, I'll be able to hire somebody.
Okay, perfect. Thank you for doing what I asked. I'll reset your case in normal about 30 days or so. If you get someone hired, bring this reset notice to them. If not, make sure you've talked to some others, or if you've selected one that you're going to hire and made a payment, bring a receipt, things like that, okay? Step in front of the clerk. DeMark Cole. My ears are stuffed up too, which is even worse. Good morning, you're DeMark Cole.
Yes, ma'am.
And Mr. Cole, were you able to get someone hired?
I had talked to Crenshaw, Wilkerson, and
Who?
Reedy,
Rennick.
and they were out of my price.
Are you working?
I'm trying to, I just started, but I haven't got paid or anything.
With what? With who?
Walmart, the remodeling fee.
Okay.
So,
So, but you know what your income is going to be on that? What you're going to make it per hour, kind of?
yes, ma'am.
So what I'm going to do is have you fill out some paperwork this morning, Mr. Cole, to see if you qualify for a court-appointed lawyer. Thank you for doing what I asked you to. You need to fill that out accurately and completely. Just leave it all blank. Do the best you can to fill it out. You're going to swear under oath that it's all true and correct, okay? Step in front of the clerk and she'll give you that paperwork. Jorge Del Fiero. Good morning, you're Jorge Del Fiero,
Yes, ma'am.
and were you able to hire a lawyer?
Bryce Keller, I paid him $300, but he says that's a charge on that, you have to, I have to pay more.
Right.
So they told me just to get a piece of paper for them to, or for the hire him as my lawyer. Like so.
He
So
told,
I gotta get back to y'all, my bad.
say it
I
again?
gotta get a paper from y'all, so he can fill out and bring it back to court.
So once you make all of your payments with him, he'll file something with us that tells us that he's been hired. Did you have a receipt for what you paid him? Okay. All right, so I'm gonna, I'll reset your case about 30 days. Do you think you'll be able to get them hired in full by then? All right, so bring the reset notice that you get from us to his office so they know when that court date is, when you make your payment, and then they'll tell you what to do. If for some reason you don't make all the payment in full, but you make partial payment, bring me the receipts as well, okay? Step in front of the clerk. Right, Kimler.
Yes, ma'am. Thank you.
Crystal Robertson. Good morning, ma'am. You're Crystal Robertson. And Ms. Robertson, this is your initial appearance. In cause number 25 DCCR 1256, you're charged with the state jail felony offense of forging a governmental instrument from June 4th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I was in correspondence with Ms. Tanika Solomon. Shortly after the holidays, I could no longer get in touch with her, so I have a consultation meeting with Wilkerson on January 19th.
Okay, perfect. So what I'll do, Ms. Robertson, is reset your case about 30 days.
Okay.
If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you your reset notice. Lance Charbino. Good morning, you're Lance Charbino. And Mr. Charbino, since you've made bond this time, have you had an opportunity to hire a lawyer?
No, ma'am, I have not. I talked to Mr. Crenshaw once again to see if he could work with me a little bit, but it's still, he owed me $4,000 down before we can start. Talked to Mr. Wilkerson, and then a Miss Robin, I forget which place Miss Robin is from, but I've talked to all 3 of them. I start work tomorrow, going back to the plants, making more money, so I'll be able to see what I can do.
Perfect. So thank you for doing what I've asked you to do. I'll reset your case about 30 days.
Yes, ma'am.
Do your best to try to get someone hired. If not, at least narrow it down to who you're planning on. If you've made any payments, bring me those receipts.
Yes, ma'am.
All right, step in front of the clerk.
Thank you.
Yes, sir.
Relatively timid day in the Judge West Court. Normally we have a Monday fashion show, but people seem relatively behaved with their attire today. It's kind of disappointing, to be honest with you. So we continue to discuss time zones in the chat. What about Alaska and Hawaii? I would propose we'll give them their own time zone, but we'll call it like Freedom Extended Time or something like that. I think that would work. Let's go back up to Michigan, see what's going on next with Judge Elmore, new contestant.
H appearances, please.
Wayne Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. O'Neill. He's joining me at the table.
Thank you. Mr. O'Neill is currently in pretrial custody and has been brought here. Also this morning, I have Mr. Sean Van Etmel. He's from the Michigan Department of Corrections to prepare today's pre-sentence investigation report. We're here today for sentencing after a plea was taken on December 12th, 2025. The conviction was for possession of a narcotic cocaine in an amount of more than 25, but less than 50 grams of cocaine as a second or subsequent drug offender. Ms. Carey, any amendments, corrections, or objections to make to the contents of the pre-sentence investigation report?
No, thank you.
Mr. Harrison, same question, sir.
Well, we have some troubling information to update. Let me get the page numbers in regard to his medical condition. On page 2 of page 284A.
I'm there.
It indicates in the penultimate line of this third full paragraph, life expectancy is 2 to 11 years. Unfortunately, that's more like 2 to 4 years.
Okay.
Yeah.
Ms. Carey, anything to add there?
No.
All right, we'll go ahead and make that change. Mr. Harrison, anything else?
What was that? I think the rest of it, I think we can handle through allocution.
All right, thank you. All right, allocution, Mr. Harrison?
Well, let's talk about the elephant in the room. Let's talk about the number, the amount, the weight. I anticipated that was going to be of some degree of concern to the court, and it probably should be. Normally, you'd have a situation like this, the court's perspective would be that this person was bringing this poison into our community, distribution to other people, et cetera, et cetera. That simply is just not the case here, despite the large amount of cocaine found on him, with him that day in the car. He was an exceptionally heavy user. So it's easy to look at the medical information, particularly the stuff that we just talked about, and say, well, this is a person who's completely given up due to having a terminal illness and has decided to ride out the rest of the time that he has on this planet in a drug-induced haze. I think that would be fair for someone to say that didn't have the perspective that is somewhat shown in the PSI and is well known to me. What is well known to me is that he's actively participated with Catholic Human Services in the jail and has attended AA and NA sessions as they were available. Most of them were NA. And he's completed the Catholic Human Services programming while in the jail. As the court can see in front of him, he has a vast amount of the little slips of paper as well as the certificates of completion for all of those programs. Now, what does that mean? What that means is that Colby is determined to do what he can to leave his mark behind when and if he does meet his maker, whether it's in the near future or a couple of years from now. He has mentored young people. I got a letter from a woman named Olivia who basically said that Colby is such an inspiration due to his perspective and outlook on life and positivity that she can't imagine that he was terminally ill at the time that he spoke with her, because she didn't know that at the time. That is typical of the conversations that I have had with people that know Mr. O'Neill. No, that is not to say he doesn't have a drug problem. Clearly he does. Clearly a significant drug problem, especially in light of the fact that there's still a pending probation violation in front of Judge Mertz in Otsego County. Has that been resolved? Not the least of which was the amount of product he had with him here and his massive amount of daily consumption of that product. Pleased to say he has a different perspective. I'm pleased to say that he's decided not to go out in a blaze of glory, if you will, Your Honor, but to exert a positive influence on the people in and around his life. Now, the guidelines on this offense is 0 to 17. He has served 102 days in jail, and as the court is well aware, the recommendation is essentially for time served, perhaps a period of supervision thereafter. Colby welcomes a period of supervision because it will reinforce the plan that he already has to remain drug-free and to remain dedicated to preserving whatever time he has left with us. His cancer has metastasized, as set forth in the PSI, and the prognosis is not good, not positive. That's not to garner sympathy. That's not to garner leniency from the court. It's simply to make a statement here that I think is pretty compelling. He had really a couple of options of what to do. This offense, this incarceration, this whole process by which he's realized he spent 102 days in jail when he doesn't have that many days left, has really put a new spin on perspective of the world for Mr. Colby O'Neill. I would encourage the court to follow the recommendation. I would encourage the court to perhaps make inquiry of Mr. O'Neill with regard to his medical condition, if there are any unresolved issues there. I don't think there are, but there certainly could be. And at the end of the day, I think a period of probation is not only appropriate, I think it would be a good thing for all of the parties involved. Thank you.
Thank you. I'm going to ask the court to follow the recommendation for a period of incarceration. This is Mr. O'Neill's third conviction for the same behavior in less than 2 years. And he had 161.5 grams of cocaine, which has a value of about, I just asked Mr. Van Eckno, about $16,000. That's a lot of personal use. And when he was pulled over, he told the officer that he was trying to make medical bills. Now, it's interesting, the report, the PSI said that he was in remission until February of 2025. In December of this year, I spoke with the jail and got them updated. I asked for some information because I was considering his medical condition when I made the offer that I did, that he had been in remission since September 2nd, or on September 2nd. The information the jail had was that his leukemia was in remission. They had discussed continuing treatment with him because he's at a high risk of it coming back, and he declined that treatment.
I'm sorry, repeat that again?
He declined. He was in remission and declined. He's at high risk of it returning, so they wanted to give him some treatment, but he declined it.
Oh, okay.
And he wished to discontinue all treatment and therapy. And whether he's changed his mind, I don't know, but in September, that was the information. And I got that from the jail in December. That was the last information they had, and he had been, according to what I was told by the jail, seen by medical personnel there because they were aware of his conditions. So I think what we have here is a person that is fairly reckless and is not taking his health into consideration. I think he is transporting and was delivering or selling or somehow involved in that, and using personal, because he was, when he was pulled over, he also had showed signs of use of cocaine. So we have someone in the last 2 years that's been in trouble for this. His wake-up call should have been the first time, but it wasn't. So I am going to ask for a period of incarceration, and for as long as the court can, under his guidelines. Thank you.
One moment. All right. Mr. O'Neill, is there anything you wish to say at this time?
Yes, Your Honor. I've had a couple of really rough years. I realize the court's aware of that. I was incarcerated last year in Otsego in February when I found out that I wasn't in remission anymore. The jail, when they were working with me, was working to do my tests on my liver for my necrosis and for my hepatitis B, for my tenofovir medicine. In September, when I was using heavily, and I have been using heavily, I was self-medicating. It's not the right thing, and I realized that. I was going through a series of tests. I just got done with the spinal tap from mass stations. Here that it was going into my spine. I have a 25% chance of survival at this point in life. If I go through a bone marrow transplant, because I did deny it, she is correct, that leaves me at a 50% chance for graft host disease. I'm very familiar with this. It's basically where the stem cells either take or don't take in my body, and if they don't, then I'm on medication for the rest of my life that helps that. But I also have a 50% chance of my vital organs failing, my heart, my lungs, my livers, and thus my percentage goes down even further. So it's a very big gamble on my own life to go through with the bone marrow transplant at this point.
But it's okay to use cocaine?
No. It's
okay. Is it okay to drive to Udall Hills?
No.
Out in the middle of the woods and then bring it, and then of course have your cell phone taken by the agents, and apparently according to this, it's detected that there were sales and transfers going on. And you also said that you were, I noticed you, because I know where Udall Hills is. I ride my mountain bike out there a dozen times a summer. So if you live in Kalkaska, where you could have gone up 37 or 31, whatever, or 37 or 31, you were coming through Cadillac. And then you were up in Manton, and you weren't on a major road at the time. Well, it was a 16 road, I think.
It was 42.
42, yeah. All right, but anyways, keep going.
No, it does not excuse my usage at all.
No, it doesn't make me think that you care about it too much either.
I care very dearly about my sobriety at this point.
But you also violated bond by testing positive for cocaine too.
This is correct, Your Honor. I'm not denying that I had an addiction. I've been going through my Catholic Human Services. I've completed 2 other courses. I keep going and attending courses. I keep going to my AAs and my NAs. I've talked with Catherine about becoming a peer support at this point, working with CHS myself, which is something that I very much would like to take my time to do, is to help other people realize, there's a better course out there. My actions have definitely stunted my life. I used to think to myself, I'm dying, what wouldn't you do? But now I think to myself, what wouldn't I do? I wouldn't give up the time that I have, not to spend with my daughter to fix my van for her to travel around the country as she wants to, working for the Parks and Recreation. I wouldn't give up the time to spend with my dog before she dies. I want to give up the time with my 15-year-old son to watch him grow. I want to give up the time that I have left, which is finite, to sit in either the county or in the prison system where I'm doing no positive anymore. I understand that what my actions have caused.
And you haven't been doing positive out here so far. How much was that stuff worth, Mr. Bennett?
I was told it's approximately $100 a gram.
so about 16,000.
So let's say it's even half of that. One of the first things you said to the agents or the officers when they pulled you over is, oh my gosh, my medical bills are $750,000 of $1 million.
I was using, definitely in duress at the time, and using that as a sarcastic humor. It was taken very not lightly, and I can't change the fact that I said that.
Yeah, but you're willing to, and you, something about helping your daughter on a vehicle? What's this about?
No, these are things that I won't be able to do.
Right, well, using anywhere from $8,000 to $16,000 on your cocaine habit, if it's just a habit and you're not using to pay for, you're not selling it, which by the way, the evidence suggests that you are. You can see I'm not really buying a lot of what you're saying today, other than your health issues. I'll accept that. I don't have any records telling me all that, but I'll accept it. So anything else, sir?
No, Your Honor, I'm at your mercy.
Well, I feel really bad for you on your health issues, but I'm not going to let that cloud my sentence today. Because you do. Everybody else here seems to gives more of a deal or more of a care about your health issues than you do. So I'm not going to. All right. You don't want to take the treatments, don't get the treatment. If you don't want to go get help from addiction, don't get help. If you want to go out there and try to tell people that you're able to spend $15,000, $16,000 on cocaine out in Udell Hills. By the way, if no one knows where it's at past Wellston. It's out in the middle of nowhere. It's out by Big M. No, cocaine's on the rise in this community, and I think you're dealing it. And I'm going to tell you, anyone who is dealing drugs in this county, in this area, needs to go to prison. So, you had 5.7 ounces. Breaks down to 161 grams. When I look at CFJ 284A, page 5, when asked if he was trying to make more money, the defendant said, quote, "It's me, just, moving one thing to another. I came from a place on Udell Hills in the woods, but it's not where I was going with this." I can't make hide or tail of that. Now, by the way, I have no idea why you weren't charged with operating under the influence. You should have been. Why? Because you even said, I'm likely to test positive. One moment. So I'm going to go back and review this a little bit more thoroughly. A lot of this report was spent talking about your health issues, and I'm very, very sorry to hear about them. But I'm not going to give any more care or concern to them than what I've seen here from you, because I see that you have just tossed in the towel. You violated my bond by testing positive for meth. You're 42 years of age. You should know better. You traveled all the way down from Kalkaska down to Udell Hills, which is west, again, as I said, west of Wellston. Actually, that would be over in Manistee County, actually, by that point in time. So you travel from Manistee County through Wexford County, potentially on your way to Kalkaska County. It's definitely indications that you are transporting a large amount. I think there's definitely evidence that you intended to sell, which means you had a possession with intent to distribute. And why? Because of the information contained here in the report that says extraction of your cell phone, quote, revealed several messages to and from the defendant indicative of drug sales. So here is a person dying from cancer who decides to throw in the towel, use it a lot, and according to this, by preponderance of the evidence, distribute it and poison other people. Yeah, you may have snowballed, and that's kind of an ironic choice of words. Everybody else, not me. So 5.7 ounces. Oh my gosh. Kind of makes me wonder where you got the $16,000. Now, I'm not here to ask a lot of questions. And by the way, I would have scored an extra 13. I would have scored them additional points in OB 13. Why? It's a pattern of 3 or more acts of felonies. You had this felony or prior to the other felony, and then you had a use, but that use could have been considered a possession, which could have also been a third felony. So you would have scored even higher points. You've already maxed out your offense variable points. And you were on parole or probation or parole for exactly the same thing. Now here's something else. I look back in your criminal history, and I know you have a 10-year gap, which means some of these things aren't counted on your guideline scoring, but you have this tendency to do what you want when you think no one's going to get away. You're going to get away with it. You're not going to get caught. And I look at these little offenses, driver's license suspended. You had what, I think 6 of them. You don't care if you got a rule that you're not supposed to. You're going to do what you want. You had a handful of these, a couple no insurances, putting people at risk. And then you start getting into marijuana in 2011. You picked up another drug case in 2019, but because you had a diversion program and you successfully completed that, that was dismissed, but sure enough, it's a drug case. Then you pick up another drug case a couple of years later in 2024. This is the one where you pled to a use, but it could have been a possession. You can't use without possessing. So that would have been your 3rd felony in a row here. You made it 4 months later and you pick up another cocaine case. And then after that case was done, you picked up, or after your sentence, you made it 5 months here. And after you were released on bond, you made it about a month. You are a danger to yourself. You don't care about your health issues, or maybe you do, but you toss in the towel. And maybe you want to spend time with your daughter or your son. You can't do it if you're high, and you can't do it if you're spending all your money. Now let's take a look here at something, because when I look about this month, the value of the cocaine, I'm going to look at your history of employment. I want to know, where are you getting your money to pay for your cocaine? What was his last job, Mr. Van Etmel? Wasn't it at a hotel?
He ran a food truck, and he said several jobs as a chef.
Okay, when was the last time he was employed? On a regular basis, not just for a month or so, a regular basis. Probably would have been in his last PSI. I'm going to look at his employment history. He's been on Social Security disability since 2021. He's been living on disability, and he receives $1,280 a month.
In addition to that, he reported operating a food truck.
But it says here that it started in 2015. All right, but that ended in 2023. because he got a new job, but I don't know what the new job is because it's not listed on here. And plus, he's no idea where he's getting his $16,000 worth of money, or he's dealing. Where'd you get the drugs in Udall Hills?
I didn't get the drugs in Utah Hills, Your Honor.
Oh, what were you out in Udall Hills doing?
I was visiting a friend out there. There's a,
Why, it says you were moving from one place to another.
I'm traveling, yes.
All right. Well, let me also take another look here.
And if I can speak to my employment.
Yeah.
I own 2 different food truck companies.
Okay.
The one that stopped in 2023 was Uptown Dogs. I'd started the Mac Attack, which is a gourmet mac and cheese business. And I operates here in Cadillac area as well as Traverse.
Okay. All right, well, let's take a look here also to stop. You lied to law enforcement 1, 2, 3, 4 times. Oh, I don't understand. I don't believe a word you're saying. You have a pattern of dishonesty. You lied here to the police several times. I don't believe really anything you've had to tell me today. Yes, definitely looks like you're distributing. Well, I don't. Well, I have some relative. I only have a little bit of information, and that talks about the phone messages on CFJ 284A, page 5. So, plus an operator while under the influence. You are a danger to the community. You are a danger to yourself. Find that there are reasonable grounds for a period of confinement. I also find that there are reasons to support the sentence. By the way, it used to be that an intermediate sanction cell had a cap at 1 year. Then they changed it and said there is no more cap, but you have to have reasonable grounds. Once I find reasonable grounds, I'm no longer capped at 1 year. Court sentences the defendant as follows: $68 state minimum fee, $130 crime victim right fund fee, a $300 court cost, since he can afford it, a $5,000 fine, a $300 attorney fee. Do we have a DNA, or was it already available? I assume it was already available.
Correct.
No DNA fee. I'm not going to place the defendant on a period of probation. Therefore, there's no probationary period. The court exercises its discretion to sentence the defendant as a second or subsequent drug offender. One moment. Which allows the court to double the sentencing guideline range. The maximum here is at 96. That's what the is that what that is with the enhancement?
Yes, sir.
All right, so the court sentences the defendant within the doubling of the guideline range to a prison term of 24 to 96 months, and the defendant receives 102 days of credit. That is extremely within the guidelines and almost right there in the middle. I find that sentence is reasonable proportion for the reasons and terms that I discussed. Mr. Harrison's going to bring to Mr. O'Neill 2 copies of 1 document. He's going to place his initials, Mr. O'Neill, you will, on page 1. Doing so neither elects nor waives in your rights and merely acknowledges receipt of your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal if you've been convicted at a trial. However, based upon the pleas in the case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Also, somewhere in here, I'm hoping that you'll get clean, you'll stay clean, and maybe live longer. Anything else, Mr. Van Apple? Ms. Carey?
No.
Thank you.
So as I've discussed, this show now has a 4th hour starting today, and we're creeping up on it. We're 2 hours in already. So we're going to discuss this in the fourth hour, and it's funny because I'd prepped some things to talk about in the fourth hour, and we might still get to some of that, but I figured that it would change depending on what's going on in court, and we're definitely going to talk about this and debate it because I have thoughts, but I want to give you this to think about until then. So he had, 5.6 ounces of cocaine on him when they caught him, which is definitely a trafficking amount, a dealing amount. But I did a little math. The DEA defines a quote-unquote dose as 100 milligrams. So he had 1,600 doses of cocaine on him. And I think that's where the judge has a real problem with all of this, is the amount of stuff he had on him. That is, if he only had weeks left to live, that's 1,600 is a ton. That's enough to kill him several times over. So when we talk about him being a danger and whatnot, I think that's where that logic comes in for Judge Elmore. 1,600 doses is a lot. So ponder that until we get to it in the fourth hour. Let's go to Ohio. We will say good morning to Judge Collada.
We are present this morning in the matter of State of Ohio versus Tyler, aka Talia Karen. This is case number 24 CR 1412. President of court this morning is the defendant with her attorney, Rachel Smith. We were last here for a change of plea on October 23rd of 2025. At that time, the defendant withdrew her previous entered plea of not guilty, entered a plea of guilty to attempted aggravated arson, felony of the 3rd degree, and grand theft of a motor vehicle, felony of the 4th degree. This court set the matter for sentencing and ordered a pre-sentence report, psychological evaluation. Those are completed. We did appear for sentencing between that date and today a couple times. Both times, although we didn't go on the record, this court did continue the matter so that additional resources could be sought in regards to a potential outcome of this case for sentencing. Did have a chance to speak with defense counsel today and listen to the plan that's been presented. The state has also reviewed the pre-sentence report and psychological evaluation along with all the other documents presented in this case throughout the while this case was pending, and is prepared to proceed with sentencing at this time.
Okay. We actually are going to do sentencing first, and we'll address the registration afterward. So with that said, Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. On behalf of Ms. Karen, we are asking the court to impose a period of community control here. And Your Honor, we make that request without minimizing the seriousness of the offense here. Ms. Karen has pled guilty to setting fire to the home of her legal parents, and has been very forthcoming about her guilt in that regard from the outset. What is given defense counsel, and I believe this court pause and allowed the matter to be continued multiple times ahead of sentencing, goes a little bit deeper than the surface of the offense. Ms. Cran has a deep mental health history that the details of which I believe are currently being uncovered as this case has moved forward. Ms. Cran does have a history of seeking mental health treatment for PTSD, as well as several suicide attempts. And Your Honor, the impetus for committing the instant offense arose from pervasive and fixed beliefs that Ms. Karen has about her childhood and the role that her legal parents did play in that. Your Honor, Ms. Karen has no criminal history, did finish high school, is incredibly intelligent, has had no issues in the jail. She's pled guilty to a felony of the 3rd degree, and is in need of mental health treatment and is open to that treatment. In the past, Ms. Corinne has been resistant to medications as part of mental health treatment, but she's expressed an openness and willingness to be medication compliant if medications are recommended as part of her treatment. Additionally, Your Honor, Defense Counsel has been working with Crossroads Behavioral Health representative, for which is present in the courtroom today, to facilitate Ms. Coran's admission into North Coast House. And it's our understanding that while at North Coast House, Ms. Coran's mental health needs will be taken care of, as well as wraparound services provided.
As well as what?
Wraparound services provided. Your Honor, we do believe that with the proper treatment and assessment, so long as Ms. Karen is willing to participate in that, will help to remedy the cause of what brought us here today. We don't believe that the public or Ms. Coran would be made safer if Ms. Coran is sent to a prison and without treatment. In fact, it's likely that her issues would become worse and she would exit prison on some date a greater danger to herself and to the public. And Your Honor, for those reasons, as well as those that have been discussed throughout the pendency of this case, we are asking the court to give Ms. Coran credit for the days that she served in the jail, to grant her community control, and allow for her to participate in the program at North Coast House for mental health. Thank you.
In regards to North Coast House, we chatted in chambers about this. My understanding is, based on our conversation, they don't put a time period in place, though I was advised it would be at least 90 days. Can it be longer? And when I was advised it could be, but can I order a certain amount of time for that, or is that up to North Coast House?
Your Honor, I was able to ask Mr. Dials prior to coming on the record that very question, and he indicated that they would be able to comply with the court. If the court were to order a period of time, they would be able to comply with that.
The technically at the range we're talking? I mean, what time periods could someone be there? Why don't you state your full name, please, for the record here?
Jamie Dials, Director of Forensics with Crossroads Health.
Is that D-I-A-L-S?
D-I-A-L-S.
Okay.
So we've never had a situation where an individual was court ordered to a specific amount of time. Typically, the stay is 90 days. However, it's not uncommon for Crossroads Health to extend that time for various reasons until they maintain some form of mental health stability or until they find more long-term housing options. So in short, yes, we could honor.
What's the longest time someone stays there?
I bet.
I know there's no written rule on that regard, but in terms of if someone had the needs that, you know, the needs that to be there, how long would you keep someone there?
So for example, I also oversee Lake County Mental Health Court, and we've had individuals in North Coast House. And as a service, they would extend people's times there at North Coast House because of the immediacy of mental health court. I would say the longest that I'm aware of is probably close to 9 months.
Okay. Appreciate that. Member Smith, was there anything else? I'm sorry.
I don't believe so.
Ms. Karen, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
No, sir.
Well, there's a lot of people that put a lot of time and a lot of effort into trying to get you help instead of the alternative. Is this a waste of their time?
No, sir.
If I was to give you this chance, are you gonna take it seriously? Are you going to work the program? Are you going to put forth the effort? Or is this just a way to avoid prison?
I will follow the program, sir.
The program requires that you take all medications as prescribed. Are you going to do that?
Yes, sir.
Is that going to be an issue?
No, sir.
Do you want this treatment program?
Yes, sir.
Do you want this help?
Yes, sir.
It's going to take some work on your part. It's not
I
just going
understand
to
that.
go there and everything's better, you know that. I know you know that. You're willing to put in that effort and the work?
Yes, sir.
And this is a big ask you're making here, or through your attorney, with the nature of the charges here. And Smith, anything else?
Your Honor.
Mr. Downey for the state of Ohio.
Thank you, Your Honor. Before I say anything on behalf of the state, the defendant's parents, who are also the victims in this case, are present, and one or both of them would like to make a statement to the court. So further.
Absolutely. And you can stand right there, sit whatever you're comfortable doing. State your full name, please, and spell the last name so court reporter can get in. Take your time and tell me whatever you'd like me to know.
Cheryl Karen, it's K-A-R-R-A-N.
Stan, can you give a microphone, please?
Yes,
Hang on one second. You can just hold it down low. You don't need to talk right into it, but.
Test.
Yes, yeah.
Cheryl Karen, it's K-A-R-R-A-N.
Go ahead.
My husband.
Oh, yeah. What's his name?
Bentley, Karen, K-A-R-R-A-N.
Thank you both.
We just want you to know that we love Talia. This isn't behavior that we ever expected. And we support any help that she can get. We appreciate all the effort that everyone has made to help this happen. I don't believe that prison is going to help her at all. And I really think that Ms. Smith has been amazing. Sorry.
Sorry.
She's been really amazing at really working to get Talia the help that she needs. And we just want her to know that we love her and we'll always be here for her.
Just Karen, anything you want to add? You don't have to. I just want to make sure. Okay. Thank you. Thank you both. One second, Mr. Downey. Mr. Downey for the state of Ohio.
Thank you, Your Honor. Clear that the defendant here is suffering from significant mental health issues that need to be addressed. And from the mental health side and the diagnoses that have been presented through evaluations and the hospital records, it does appear that the treatment plan presented here does appear to address those issues. I think the difficulty for the state has been that the defendant also separately realizes that she committed a serious crime and that crime was retaliatory in nature and unprovoked in the moment. She says in the pre-sentence report that she purposely went to the house to confront her parents, that after conversations with the parents, she was unsatisfied by their responses. She declined to leave the residence and then waited till they were gone and decided to set fire to the home when there was no active threat against her at the time. At the time the pre-sentence report was completed, it did not appear that she had remorse for her parents. It would seem to be more remorse that she was caught and now in the criminal justice system. And even if the defendant's delusions here were in fact true, her conduct would never be justified. So certainly not legally, which is why there's not a legal defense here, but also morally. So it's, from the state's perspective, what she did is just straight up criminal conduct. So I guess where the state struggles is then what is appropriate here, because her parents, the victims, want treatment. They've been extremely understanding and forgiving from the very start of this case when I first had contact with them. And I think that prison would certainly be justified here. I mean, the crime is serious. I mean, just the reduction here that the state gave to a felony 3 is pretty significant given the damage that was caused here. I mean, their home was destroyed and has to be completely rebuilt. I mean, hundreds of thousands of dollars of damage. If the defendant were to go to prison, she served a little over 9.5 months here. So the court has roughly 44, give or take, months to play with here for prison is what she'd be looking at, considering jail time credit.
Like 38.
36 from the felony 3 plus 18 from the...
Oh, I forgot about the other charge. You're sorry.
And considering what was just said here today about North Coast House, I know I'm making a couple assumptions here, but she goes there and does treatment for 9 months where she's in a facility where she's not out in public. We're talking about, roughly about 3 years is what, if she went to prison, it'd be 3 years that she's away from society, right? So what is the right recommendation here? Prison for 3 years where we know that she is going to be away from society and is not going to be a danger to those around her. But in no way am I jaded and thinking that she's going to get the appropriate treatment in prison. And arguably, she might come out worse. However, given the nature of this offense, prison seems like the appropriate sentence from a punishment aspect. So the mental health professionals and the treatment professionals that are here who have been involved in this case, they appear to be confident that the defendant can receive treatment that is adequate to not only treat the deep mental health issues, but also protect the defendant and those around her, in the sense that if she receives this treatment, then she will not commit further serious criminal conduct of this nature. And I'm not a mental health professional, so I have to defer to them, I think. Both of these options here, I think, seem pretty even when it comes to pros and cons. And the issues that the defendant has today that I think led to this seem to be something more recent. She has led a law-abiding life for a majority of her life. Best we can tell from looking at records and timelines is that at some point, this offense happened October 2024. At some point after January 2023, so about a year and a half, almost 2-year period, is when these more serious issues develop. So in terms of the defendant's entire life, this is something that's more recent. And when the defendant didn't have these issues or was receiving treatment or whatever she was doing before, she was safe and wasn't a dangerous society. So based on what the mental health professionals have said, I have to think that if she were to get adequate treatment, that she would go back to that state. And from the start, the state has indicated that it would be amenable to treatment if an appropriate treatment plan was presented. So I'm going to go along with the joint, or with the recommendation of community control, make that joint recommendation. I do so with a lot of hesitation. I know ultimately it's not up to me, it's up to the court. But I think the treatment plan should be done so with the understanding that if the defendant does not follow the treatment plan, then there will be very quick and serious consequences, which would be the termination of her community control in this case. I don't believe there's any restitution submitted from the victims here. The defendant does not have any money anyway, and given that it's her parents, I have not received any information from them about that. And so there's nothing further from the state this time.
Thank you. Well, I've considered the pre-sentence report and investigation, the psychological evaluation. I received other evaluations that were done throughout the pendency of this case. There was a evaluation for NJRI that was done. We've had several hearings scheduled where we've talked and discussed this and continued the hearing to get more information. All that's being considered by this court. The victim impact statement, I read and considered that. I've considered everything said here today by all the parties who addressed the court. I have considered the particular facts and circumstances of the offenses involved and the nature of those offenses, and I've considered all this in light of the purposes and principles of felony sentencing set forth in 2911. As for the factors in 2912 indicating it's more serious, the court notes that the defendant's relationship with the victims facilitated this offense. The victim suffered serious psychological harm as well as economic harm. And then other relevant factors, I mean, this destroyed their whole home. Most arson cases we have don't cause the damage that was caused here. You know, someone lights a small fire, there's a little bit of damage. That's what we typically deal with in an arson case. That's not what most people think about when they think about arson. They think about what happened here, quite frankly. But that's not the normal arson case. That's what we have here. As the prosecutor mentioned, it was retaliatory in nature, it was unprovoked. Those are all factors indicating it's more serious. Nothing makes it less serious. As for Recidivism factors, the court notes there's no genuine remorse. It hasn't been shown. It hasn't been shown in the pre-sentence report. I mean, she feels bad for her parents, but then she immediately turns it around. And now there's the mental health issues that are in play here. When she starts talking about the reason why she did this, and there's no remorse in that part of it. There's no remorse here. And given the chance today, I mean, she doesn't have to make a statement, but she didn't, and she didn't display any here today either. Factors indicating recidivism is less likely. There's no prior criminal history here at all. No juvenile delinquency adjudications, no convictions as an adult, law-abiding life. Her entire life up until this. Other relevant factors indicating recidivism is less likely. I don't know if it indicates recidivism is less likely more than, I mean, obviously the mental health issues play a significant role here. If they can be addressed, then the hope is that that would lessen the chance of recidivism versus the defendant just being a bad person. I mean, obviously there's an argument that there's significant mental health issues that could cause there to be recidivism could be more likely in the future. But with treatment, hopefully that can be addressed. The lesser included offense here of count 1 is a felony of the 3rd degree. There's no presumptions one way or the other. Prison certainly is consistent with the purposes and principles of sentencing when you look at the nature of the offense involved. And that's been the court's struggle here, and that's, you know, again, a lot of what the prosecutor said, the court's been struggling with those same issues in terms of just the nature of the offense itself. But due to the significant mental health issues that are in play here, though they don't amount to a defense, they certainly are relevant, are genuine, are significant. Also taking into strong consideration the victim's desires here, the court will find the defendants amenable to an available community control sanction. I'll give you a chance, but you're getting one chance here. This is a big opportunity. You should hopefully view it as an opportunity, not a break, but an opportunity that you're being given here. And there's a difference there. If you view it as an opportunity, hopefully you work at the program, put forth the effort. If you view it as just a break that you got lucky, then we're out of luck. I'm going to put you on community control sanctions for a period of 3 years. I am going to order that you serve 6 months on the lesser included offense of count 1 and 6 months in the jail on count 2. I'm going to run those consecutive for a total of 12 months. You have credit for 286 days. So a total of 12 months in county jail. I'm going to order that you enter the dual diagnosis programming at North Coast House as soon as the bed's available, and then get you in. As soon as that bed's available, you can be released from the jail. The balance of that 12 months will be vacated. So I just did that amount, so we have enough time to get you there. My understanding is it's not that, won't take that amount of time. Is that correct, Mr. Niles? You're going to enter North Coast House. I'm going to order for now for a minimum of 6 months. If we get to a point where it's time to be discharged and there's nothing more that can be done, something can be filed with the court and I'll address that. But I'd like to put that in place now. Will that work, Mr. Dowles?
Yes, sir.
All right. To participate in the programming there, successfully ultimately complete that program. Further conditions, I want you to get a full psychiatric and psychological evaluation, follow recommendations. So recommendations for medication, Whatever medications are recommended, you need to follow those recommendations and take that medication as prescribed. If you don't, we'll be back here for a violation. You understand that?
Yes, sir.
In terms of psychological evaluation, follow all recommendations, which will include individual counseling, to include an EMDR therapy. I want you to participate in that. I want you to, further conditions, you're not to use any drugs or alcohol. That includes even marijuana. No marijuana use. Shall submit random urine screens when requested. They have to be negative. I want you to attend at least 3 AA meetings a week and have a sponsor. Ultimately, you're to obtain and maintain full-time employment or education. If you want to go to school, get some type of training, that counts as well. But on a full-time basis, you're ultimately going to be keeping yourself busy on a full-time basis, working or going to school or some combination of the two. You understand that?
Understood.
You're to utilize any case management services that are available with the treatment program for assistance and help, and utilizing the resources in the community. Pay court costs and supervision fees. Follow registration requirements that are going to be provided to you here in a moment. I want you to sign whatever releases probation needs from you so that they can contact counselors or therapists if necessary. So you need to do that. You're going to have one doctor that can prescribe you medication. If there's specialists, that's fine as well. But make sure probation knows who the doctors are that you're getting prescriptions from. You can go get them from those doctors. You can only fill them at one pharmacy as well. Megan, is there anything else I should be thinking about here, considering?
No, Your Honor, thank you.
Lisa, anything else?
No, Your Honor.
Giles, have we covered everything we need to cover in terms of for the North Coast House there?
Yes, Your Honor.
Okay. Ms. Karen, you understand all the conditions of your community control sanctions?
Yes, sir.
Any questions for me?
No, sir.
Need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another criminal offense, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. Technically, I could impose more restrictive sanctions, including local jail time, or I can and will terminate your community control sanctions and send you to prison. And if that happens, and that's what will happen if there's a violation, it'll be 36 months in the lesser included offense of count 1, an additional 18 months on count 2. That'll be consecutive for a total of 54 months in prison, which will also be consecutive to any other prison sentence that you may be serving for some other case, if some other case happened, or that you're being sentenced to at that time. So do you understand all that?
Understood.
Do you have any questions for me?
No, sir.
In terms of sentencing, I know the registration, anything else that we need to address, Mr. Downing?
Yes, Your Honor. The victims indicated that they don't want a no contact order. They want to be able to speak with the defendant, have contact with her. However, they don't want her at their residence, either the residence in this case or the whichever residence they're currently staying at.
So you are not to, and I'll grant that as a condition of probation, you're not to go to your parents' residence, either the home where this happened or the home that they're currently residing at. You can have contact with them in terms of phone calls, letters, emails, texts, even seeing them if they come, but you can't be at the house. Is that what you're requesting? be at the house, can't be where they're residing, you understand that?
Understood.
Ms. Smith, anything else as far as sentencing goes?
Not at this time, Your Honor.
All right. Well, Ms. Karen, I need to advise you at this time, as you were told at the time of plea, you will be required to register as an arson offender. I need to advise you of what those requirements will be. And then I'm going to have you sign this document indicating that, acknowledging I read them to you and you understand them. You don't have to necessarily agree with it, but you're acknowledging I read it to you. You're going to get a copy of this, so I'm not expecting you to memorize what I'm telling you, but I'm required to read it to you, so I'm going to do that at this point. So, do you have a middle name? Do I have that, or is that?
Legally, yes. Alexander.
I guess not.
Your Honor, the legal middle name is Alexander.
Alexander. I'm going to put that on here just for the form. And I'm going to use the address, expected residence address. I'm going to use North Coast for now. What is that address, Mr. Downs? You know, we don't know.
Sorry, I don't know. I know it's in Concord now.
Nobody knows this address?
The 255 Center Avenue is wrong then? Correct. Okay.
Used to be.
I thought it was, that's just the Menor Avenue address.
It's moved from Menor Avenue recently. I can find out.
How can you find out? Just the texting somebody? All right. Then I'm going to go with these, and then we can just add that after. So I'm going to, your expected residence address, I guess at this point, is the North Coast house, correct? And
Understood.
after that, you don't have any plans at this point as to where you expect you would be residing, or do you?
No, sir.
Well, we'll use that address for now, and we'll give that, I'll get that here in a moment. But let me read you the requirements, your obligations you're going to have. You've been convicted of, pled guilty to an arson-related offense. You will be required to register in person with the sheriff of the county in which you establish residency within 10 days of being released from incarceration, or within 10 days of your sentencing hearing, if not sentenced to incarceration. So since you've been sentenced to incarceration, once you get out, you have to register with the sheriff's department within 10 days. That is at 84 North State Street in Painesville, and I'll read that to you later as well, and you'll have that, but that's where you're going to need to go to register. You will be required to provide the sheriff certain information, which will include your social security number, your full name and any aliases that you use, your residence address, information regarding the offense which you were convicted of, any description of any scars, tattoos, or other distinguishing marks on your person, the name and address of any place where you're employed or attend school, any driver's license number, commercial driver's license number, or state ID card number issued to you, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle information number, and a description of the vehicle must also be provided to the sheriff. You will be required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of your registration. You'll be required to remit a registration fee of $50 to the sheriff unless that fee is waived. After the date of the initial registration, you'll be required to re-register annually. You must update and/or amend any of the information described above that has changed, and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you initially registered. If you are registering in a different county than your prior registration, you must provide notice of your change of address to the sheriff with whom you most recently registered. You'll also be required to pay a re-registration fee of $25 to the sheriff. Now I'm going to waive the initial $50 registration fee, and then the $25 re-registration fee. At that point, you should be working, and that should be assumed should be all right. So put in the entry that the Initial registration fee of $50 is waived. Now, you'll be required to comply with all the above described requirements until your death, unless your sentencing court determines otherwise. Since your expected residence address is in Lake County, you'll register in person no later than 10 days after you're released from jail with the Lake County Sheriff's Department at 84 North State Street, Painesville, Ohio, 44077. Your failure to register or failure to verify your residence at the specified times will result in additional criminal prosecution. You understand that?
Understood.
All right, do you have any questions at all about any of these registration requirements, what you're gonna have to do?
No, sir.
All right, and I'm gonna hand you this form right now. In line 10, it reads, I acknowledge that these requirements have been explained to me. I understand the requirements and I must abide by them. And then I have you sign this again. It's acknowledging you understand it. So line 10, I'm gonna have you place your signature.
Your Honor, I have that address.
Now, get that back to me for 1 second, Stan, please. Let's get that on there first before she signs. What is it, Mr. Downs?
7480 Auburn Road, Concord Township.
44077 there, I think?
Yes.
Is there a phone number, or would that be the 241 number, or is that not? You don't know? That's all right.
Okay.
That's all right. All right, here you go. Mr. Karen, you signed the document?
Yes, sir.
I'm going to place my signature on line 11 now that reads, I certify I specifically inform the offender of her duties. As set forth above, as you indicated. To me, in understanding those duties, I place my signature. We'll have the bailiff make multiple copies. We'll get you a copy, your lawyer, the prosecutor, sheriff department. I think that covers everything. Mr. Downey, is there anything else that we need to address or should discuss?
So for the judgment entry, I was just putting there that the defendant was advised the arson offender registry acknowledged signed open court, initial $50 fee waived. Is there anything else the court wants specific for that?
Initial $50 registration fee.
Correct, yeah.
It's hereby waived. No.
Thank you.
I did make that a condition of community control also to register.
Yeah, thank you.
Ms. Smith, anything else?
Not at this time, Your Honor.
All rise.
It's TCF Live on a Monday. I hope you're all enjoying your day. It's been an interesting day in court so far. A lot of good cases, heavy cases, but certainly enjoyable / educational to watch. So a couple of things. Got my eyes on a lot of different courts. Ashley, you'll be proud in Clayton County in hallway court. I only count 7 people in the hallway today, so they seem to have had a relatively light weekend there, so good for them. Also, I wanted to show you guys this. I never go to Judge McBurney's court in Georgia, and the reason that I don't is that he's always up on his mic, so it sounds like a fast food drive-thru. It's like, Whopper with cheese. And it's very hard to understand him, but I do always admire how he titles his streams. Judge McBurney's Maybe Criminal Trial Calendar. I just thought that was kind of cute, honestly. So at the top of the hour, lots of things to discuss. Barbara was asking about court interpreter pay, so we'll cover that. Wahoo is asking about compassionate release in Michigan. I pulled up information on that, and I do want to get into that case from Judge Elmore's court. So that'll be TCF Overtime at the top of the hour. In the meantime, let's go to Judge DeSanto. We'll spend a few minutes with her. I need to step out of the studio for a couple of minutes while you guys see what's going on there.
Mr. Moss, your name for the record, please.
My name is Lebanon Moss.
Okay, thank you. And Counsel, your appearance, Mr. Calapari.
Good morning, Your Honor. Sean Kramer. I'm as the arraignment plea for reading my place yesterday.
All right, thank you. And appearance for the people for the city of Riverview.
And good morning, Your Honor. For the record, Terry Johnson, P70773, on behalf of the city of Riverview.
All right, thank you. Okay. And so, Mr. Calapari, your name for the record, please.
And Daniel California.
Okay. And so today is the date scheduled for Mr. Calapari for an arraignment pretrial and for Mr. Moss for a formal hearing. I understand that these are on two separate matters, but given the frequency of both of your visits to the court and the communications within the Riverview Police Department amongst yourselves, the court found it appropriate to have both of your cases called simultaneously. Mr. Shunke, as to the arraignment on your client.
Reading my place was beautiful.
Court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and as to the pretrial counsel.
You know, the adjourning this matter for some comparison.
All right, so this court's going to adjourn this matter for compliance by Mr. Calapari. February 23rd. You're not here that day, but I mean, 4 weeks is February 9th. You're back that day, that would be 30 days. So we can do that thing.
Wait then.
Nine. 9:15 a.m. Okay. The court's going to order a $3,500 personal bond. Now, let me be very clear. So the people are moving to dismiss Mr. Moss's charge of littering, correct?
That is correct, Your Honor.
And this is a result, I believe, of the tree bark at issue with Mr. Calapari's criminal charge of assault and battery, correct?
That is correct, Your Honor.
Okay.
Just for the record, I believe there was a dispute between the parties and it appeared to be mutual, so we, the case against Mr. Calipari is dismissed. We thought it would be in the best interest of justice to do the same for Mr. Moss.
Okay. Did you two hear that?
I did.
And what part of that did you hear?
The entire thing.
Okay. Tree bark. Tree bark. A piece of tree bark is what prompted you all to be in court. Tree bark. Because somebody didn't like it on their car. Who cares? Who cares? And who cares what tree it came from? Is it really that important? Mr. Moss, is it really that important?
Sir, I have no trees on my property. It is.
So if you're at a store, sir, and a leaf falls on your tree, or on your car, what do you do about it?
Okay, but we're not talking about one piece of tree bark here.
That wasn't my question.
A leaf is nothing, but we're talking about numerous pieces of tree bark in this instance. Yes, only one placed on my vehicle, but still numerous pieces of tree bark over time.
Sir, again, if you were at a store, say a piece of tree bark fell on your car when you were at a store, what would you do?
Leave it.
Right. Right. Would you call the police?
Not if I was at a store.
What's that?
Not if I was at a store.
Okay, and you would remove it. Where would you put it?
I don't know. I'd probably either inside my vehicle so I could get rid of it, or, depending on conditions outside, maybe back outside. I'm not certain. It would depend on the moment.
Okay. Okay. Mr. Calapari. What about you?
Your Honor, this isn't about tree bark. This is This guy has been,
That wasn't my question. Because clearly the two of you are so antagonistic of each other that you drain the resources of the Riverview Police Department. Over 800 calls have been made in less than 5 years. Over half of which involve specifically Mr. Calipari. But Mr. Moss, you contacted the Riverview Police Department over 800 times via 911 and non-emergency lines. There are definitely not 800 extremely urgent, life-threatening emergency situations that would have prompted you to contact the Riverview Police Department. Mr. Calipari, you 100% antagonized Mr. Moss. If there is tree bark anywhere, who cares? Who cares? Do you have a leaf blower?
yes,
Great, blow it off your lawn, onto the street. Pick it up and put it in the trash.
right, but yes.
Do not conduct yourself in such a fashion that you're going to antagonize Mr. Moss. And I'll state for the record, Mr. Moss submitted a video. I don't remember at what point there was a video. It was silent because I think he may have been recording or something at the same time. I don't know. But Mr. Moss was videotaping your house. He was videoing your house, Mr. Calipari. And yes, while it's frustrating, it's all of those adjectives. You come out of your house and then you come right to the property line. And you're running your mouth saying something I don't know because there wasn't a volume. Why even leave your house to go confront Mr. Moss?
Your Honor, we don't have a doxing law in this state, but he's doxing me.
Okay, excuse me, just one moment. Do you think that by going and speaking to him, he's going to stop?
Yeah, no.
No, so why bother? Why bother? If you think that there's a violation of a law, then make a police report. If you think that Mr. Moss is doxing you, which I believe that there is something in the statutes regarding that,
I've looked, Your Honor.
then,
I don't think there is.
well, if you make a police report, sir, and the police officers send it to the Wayne County Prosecutor's Office, they'll do their research to determine whether or not there's a charge. I don't know, but that's how something happens for a violation of a law. It doesn't do there's zero benefit by going over to the property line to say something to Mr. Moss, other than it's going to prompt another police report, another case, and you two coming back to court. If you two want to visit the court that often, come by whenever you want. It's open. You don't have to wait till you have a criminal case here or a civil infraction. Come whenever. Come whenever. Let me be very clear, Mr. Moss. Mr. Calipari has been given a citation regarding some of the issues that are going on. I believe it's in the back of the house. During this adjournment period, there is not to be any communication with anybody working at his house or with Mr. Calipari, or any videoing of Mr. Calipari doing his work. You're not to live stream any video of Mr. Calipari doing work in the backyard. Am I clear on that?
Yes, Your Honor.
None, zero. Not a live stream, not anything. Oh, here's Mr. Calipari finally doing what he's supposed to be doing, or whatever else is going to be. Not happening. Not happening. There's not to be any calls to the Riverview Police Department regarding Mr. Calipari's home within the adjourned period of time either. Are we clear on that?
Yes, Your Honor.
Mr. Calipari, if Mr. Moss is doing any of the things that I just stated he is not permitted to do, which is going to be put into a written order, don't address Mr. Moss. Contact your attorney. Contact your attorney. or then your attorney will contact the prosecutor that can file whatever motion needs to be filed. Am I clear?
Yes, yes.
Yes, Mr. Johnson.
Your Honor, just in light of what has been going on, I would place on the record that should anything come back through this court, the city of Riverview will look to prosecute to the fullest extent of the law. There will be no such consideration of things, so I just want to make sure that's on the record so both parties are aware that if anything comes back, we will be looking to prosecute to the fullest extent of.
All right, thank you. Do you both hear that?
I did. Yes.
Mr. Calipari, you're not to speak to or address Mr. Moss. We'll see you back on February 9th, Mr. Calipari, with those repairs being done. And Mr. Moss, your civil infraction is dismissed.
Your Honor.
Have a good day.
Ladies and gentlemen, it has been a crazy, crazy day here at TCF Live. I don't even know what to say. The only thing I can point out is, as I mentioned in the chat, at least it's not the bloody loogie from last week in Judge Wolf's court. Which, by the way, that is its own video that goes live at 2 p.m. Eastern today. So if you haven't seen that case, check that out. It's pretty nuts. It is that time, my friends. Let's transition into TCF overtime. So this is obviously a new thing for us here, something completely different from what we've been doing before, and here's my vision for the fourth hour. It's going to be different every day. It'll evolve as we go. The idea here, though, is to open up some discussion based on what we've seen during the day, plus things that we might not otherwise cover here on TCF, but embrace the community, have some discussion, not just watch court like we do the other 3 hours, but actually discuss it a little bit, trade ideas, agree, disagree, all that kind of stuff. So if you are a channel member, you can go to the Discord right now, and under the member announcements area, you will see a link. You can join me in this hour and express your opinions. The link to do that is there. If you are a cast member for Sidebar, you'll find it in our private chat as well. So I had a whole list of things to cover today, but as I kind of figured would happen, we have other stuff that has come up. So let me get things pulled up, and we can go through those things. Let us see here. There we go. Let's start off with something that Barbara asked about, and that was, let's go there. There we go. This was court interpreter pay. So I pulled together some data, and it varies, but here's some examples. On the federal level, and pretty much everybody charges by the half day. There are a couple of exceptions. But on the federal level, a certified court interpreter makes a minimum of $320 an hour, or $320 for their appearance. So it's quite costly. If they have to do a whole day, it goes up to $566. And anything over 8 hours, it's $80 an hour to be charged. It's quite expensive. California, it's $175 for a half day, $350 for a full day. In Colorado, $55 an hour. So Colorado is pretty cheap. So if you're going to be a court interpreter, don't do it in Colorado. Oregon, $80 an hour. Minnesota, $75 an hour in person, $65 remote. A 2-hour minimum. New York is $220 for half a day, getting closer to that federal amount there. Nevada, $49 an hour, or the prevailing local court rate, whichever is higher. So apparently there's some variance there. And then in Washington State, $65.63 an hour. That's very specific. And an ASL translator, $77.71 an hour. So you could see where these courts would definitely be frustrated, I suppose, by the need to have court interpreters just based upon the cost alone. This is not cheap to do. I was not able to pull data on Florida, Barbara, so I'm not sure exactly what Florida charges, but it's obviously incredibly expensive to do this. And, I can see why. And it frustrates the courts, too, obviously, when they have to use an interpreter because it slows everything down so much. Is it Middleton who says it's like triples the time that it takes when they have to work through an interpreter? And he's not wrong. It takes a ton of time to do it. So, yeah, you can see why some people, I suppose, would push to have English be the official language just for cost savings alone. That is a crazy amount of money for accommodation. And we see this, every day in all the courts. Pretty much everybody needs an interpreter now, at least once during the day, it would seem. And if you consider the thousands of courts that are running across the country in a day and the couple $100 it's going to cost them, that just adds up really, really quickly. But obviously that's its own industry now, so they're definitely not going to push for it to be, changed or eliminated. And ultimately, for the sake of justice, we have to do it. If the person can't speak English, they have to understand what's going on, so I get that. But it is an incredible burden to be sure. So let you find that interesting. Let's talk about Michigan for a second and the compassionate release data. Now, I Googled this, but Wahoo, you were asking about compassionate release with relation to that Judge Elmore case. Says here, Michigan's compassionate release allows early release of inmates with severe illnesses or incapacitation, often initiated by the sheriff or physician for those with a short life expectancy under MCL 771.3H. Though specific eligibility can vary, requiring formal motions, medical proof, and court approval, focusing on terminal illness, debilitating conditions, or elderly inmates unable to care for themselves. So one of the things you mentioned, Wahoo, when we were watching that case was the idea that they could appeal to the governor for the compassionate release. But the way I read it here, it's not a function of the governor in this case. It's a function of the court. Perhaps the governor could consider a pardon and do it under the pardon guidelines, but an actual compassionate release is a matter for the court, it looks like. Eligibility factors: a prisoner with a life expectancy of 6 months or less as determined by a physician, a prisoner that is seriously ill, injured, or physically or mentally unable to care for themselves, or the elderly in some cases can also qualify. A county sheriff can notify the court, or inmates' families can start the process. A written motion detailing extraordinary or compelling circumstances, medical evidence is then brought to the court, and then the court reviews it. So in the case of Judge Elmore, assuming this would go back in front of him, and not in front of Judge Wiggins, I don't know if it'd be a district court or a circuit court matter at that point. I assume that Elmore would still hold jurisdiction because it was his case, but in either case, it has to go to the judge, and if it was in front of Judge Elmore in this case, I can't see him actually granting a compassionate release. Could be wrong, but that wouldn't be my read on it based on what we saw out of the judge. So you're welcome, Wahoo. Like I said, it wouldn't surprise me if they could appeal to the governor for like a pardon. And that could make sense, but otherwise it would have to go through the judge, and good luck with that. Okay, so let's talk a little bit about this Judge Elmore case. And for anybody who missed it earlier, the 20,000-foot view of it is this. You have a defendant who is in Judge Elmore's court for sentencing. And he was being sentenced on some cocaine charges. He was caught with it. He had enough that was a trafficking amount. Specifically, I did the math, and you'll recall that I shared this if you were with us then. What he had worked out to about 1,600 doses worth of cocaine, so not a small amount. But the crux to this is the guy has leukemia. Supposedly he's terminal and he's got about 4 months to live. And judge ended up giving him some number of months in prison. If you remember what it is, go ahead and put it in the chat. I didn't write it down, but it translated, if I recall correctly, to a minimum of 3 or 4 years. So he's, if he is indeed terminal, with that, he will die in prison. We had a whole lot of discussion in the chat about if this was the right thing or the wrong thing to do. Should he be sentenced with that amount of cocaine? He's terminal, 24 to 96 months. Thank you, Wahoo. That's what I thought it was. But I didn't recall for sure. We had the discussion, is he deserving of this? If he's just doing cocaine, is he medicating for it? Is he medicating for his illness? That sort of thing. And does it really harm anybody? And the majority of you felt that he was not harming anybody and that the judge was not being compassionate. I'm going to take a counterpoint on this one. And I'm going to say, despite the situation, it was the right thing to do. And I'm going to say it for a couple of reasons. First off, the sheer amount of cocaine that he had and the number of doses that it works out to, and the belief that he was trying to sell it, by definition, would make him a danger. If he indeed has 4 months to live, 1,600 doses, I think I mentioned this when I called it out earlier, would be enough to kill him several times over. So I don't know if you can argue that he needs that much to medicate himself. And even so, if he did need that much, why is he traveling in his car with it? Why isn't it just sitting at his home? So if he's got that much and he's traveling in his car, the question of trying to sell it does come up. And that does make him a danger. You could especially argue, too, that if he is terminal and he's out doing this kind of thing, would it then follow that he's even more of a danger potentially because he doesn't give a damn? Because he's going to check out soon anyway. So if he takes other people along the way through his dealing and somebody gets it and overdoses on it and dies, does that really change his equation on things? Probably not. So that's something worth considering as well. And I would also argue this, and I'm going to bring out the faith end of Dan here perhaps a little bit. But I find it personally hard to excuse that kind of behavior just because you're dying. I don't view an illness or an impending death as an excuse to suddenly lose your morality. I just don't. So, I mean, I feel sorry for the guy. Leukemia sucks. I know people who have gone through it. It's not a good thing. Everybody that I know who has gone through it has died. So it definitely, it doesn't end well, for sure. But is your own mortality an excuse for bad behavior that potentially affects others? I don't think it is. And again, that is probably faith-based Dan talking, and if you disagree with me, I'd love to have you to, debate me on it, and we can have a good discussion on that. But that's where I struggle with this one, is I don't think that it gives him any kind of right to go out there and misbehave. And you know, there was question about whether or not, well, was he trying to pay his bills? Okay. It would be better for him to not pay his bills and go bankrupt if he's about to check out anyways, than for him to potentially harm his community by dealing cocaine and somebody ODs and dies. I mean, let's be real. Who would you rather take the pain? The big corporations that are going to write it off and get a tax deduction for it when he defaults, or the community and the potential harm it could bring to have cocaine, which is, you know, laced with who knows what, potentially out there endangering others and fueling their habit. I'm just saying. That's kind of my take on it, but I'm guessing that Lindsay has a different take, or maybe she agrees. Let's find out. Hi, Lindsay.
Good morning.
How are you?
I'm okay. How are you?
I'm good. You're showing off that new microphone setup you've got.
I am
for
showing
Sidebar.
off the new microphone setup.
You sound so much better, by the way.
Thank you. Thank you.
It really does make a difference.
I have to make this brief because I'm technically at work right now. But I think I took a journey during that that particular case. I started off with a kind of a mindset of like, he's dying, you know, let it snow, as Michael said. But yeah, then I had time to really think about it. And it's like, that's still introducing it into the community somehow. It's still enabling someone who might be selling it to continue to sell it somehow. I think in the end, I landed on it. It wasn't as okay as I maybe wanted it to be initially. You know, I just wanted to be like, he's dying and the whole situation sucks. Just let it go. But, you know, to your point, that was 1,600 doses of the drug. And I also have to remind myself that that courtroom sits about 50 miles south of my hometown. So that's not too far from a community where I could have a family member or a loved one encounter someone who had made a purchase from this guy, and who knows what that could entail. So yeah, I took a journey. I took a journey during that, and I just kind of had to share that out loud because that was a lot to type.
Well, I appreciate that, because to be honest with you, my initial reaction was pretty much the same. It's like, I'll let him have his cocaine. However, then I did the math on how much he's really carrying and why is he carrying it in the first place. And then my morality kicked in. And honestly, you know, look, if your life's coming to an end, that sucks, but it doesn't give you permission to harm others on your way out.
Yeah. Another viewpoint to present, and maybe a kind of a similar viewpoint. The writer Elizabeth Gilbert, she recently lost her partner to pancreatic cancer, and her partner was in recovery from, I believe, opioid use. And in the last year of her life, Rhea was her name, started her habit up again with the mentality of like, I'm dying, you know, why bother? And it wound up putting Elizabeth in some seriously compromising situations to aid and abet her partner in, you know, getting what she needed to support her habit. And so that's another thing to consider as well, is like, what are you putting those close to you through if you are choosing to do this at the end of your life? Anyway, this stuff I've chewed on while doing Monday morning reports. But
there you go. I mean, I guess there's something to be said for dying with grace and dignity and honor, because we're all going down that road eventually. Everybody owes a death, and you know, you're not going to cheat it. So does it make any sense to take out others on your way out? I'm a hard no on it myself, but.
Agreed. I think a less harmful way of doing it was, so when my grandfather was in palliative care, he was well known for his love of Mike's Hard Lemonade. So as they were swabbing his lips with like fluids to keep him getting too dry, it was Mike's Hard Lemonade instead of water. Like that's the way to go down. You know, you're not hurting anybody with a bottle of Alcopop.
Nope, I agree.
Hard drugs are.
All right, back to work with you, Lindsay. Thank you.
Thanks, Dan. Bye.
Have a good day. Lindsay, ladies and gentlemen, you can see her on Sidebar Tuesdays and Thursdays. Well, not this Tuesday, because she's got to slide rocks down a sheet of ice, because that's her pastime. But you'll see her Thursday, so that'll be fun. Anybody else got any thoughts on the matter? Feel free to call in, chime in. But it's kind of where I'm at. You know, there has to be some morality to things. I would argue, especially in your darkest times, especially in your hardest moments, is when you need to shine with grace and dignity and morality. And it would appear that guy's not. And it's unfortunate. I don't want him to have to die in prison, but he's probably going to. And unfortunately, in my angle anyways, I think he's earned it. So that's kind of where I'm at with that. Okie dokie. If you have more to say on that, like I said, feel free to call in if you're a channel member. Link is in Discord, and for the Sidebar cast members, it's in our private chat. I have time. Let's do this. I wanted to discuss something, and I've been working a theory kind of over the weekend that revolves around all of the crimes against children cases that we see. I don't recall seeing one today, but we've definitely seen them a lot. We'd seem to not be able to escape it, to be honest with you. But I wonder how we've gotten to this point where it is so prevalent and everything, it's not everything, but every court seems to be dealing with this almost on a daily basis, where somebody does something bad to a child. Barbara confirmed none today. Good. I didn't think there was. Just other stupidity. But I got to think about how we went there, and I have a theory, I have a hypothesis, and you might agree or disagree, but this is where I'm at with it. Who remembers these things? Raise your hand in the chat. Put a 1 in the chat if you're old enough to remember missing kids on milk cartons. I most certainly am. But this was a thing that definitely popped up in the 1980s. And I would argue that it is a basis, or at least a starting point, for where we are at now. And follow along with me, because it's a little bit of a journey. But so many things that we do in society start off with good intentions. And I think the intention here was, these kids are missing, everybody buys milk, let's put them on a milk carton. And this actually started, I think it was in Iowa, was the first one. It was a local dairy who knew of this local kid who was missing and put him on a milk carton. And then that got notoriety, and it went national and became a thing. But I think what we ended up doing, I think that was the start of shifting risk, and not necessarily in a good place. Because let's think about what happened as we were starting this. So you've got the 80s, and you've got a kid that goes missing, and then suddenly everybody thinks that's a good idea, so they put it on their milk cartons. But it went beyond that. You would start to see it on boxes for pizza, for example. You go to the local pizza place and they would have the missing children on the boxes. You'd see it on the side of trucks where they would put faces of missing children. And along that same time, you also had John Walsh. I think his first name was John, the guy who did America's Most Wanted. It was Adam Walsh, I believe was his son, who went missing, and that became a national thing. And then he went on to do America's Most Wanted, where he's calling out missing children and criminals and all this kind of stuff. And I would argue that what began to happen was this shift towards fear. And the milk carton thing, honestly, kind of fell apart anyways, fairly quickly, because what happened there was they realized, the milk industry did, that they could get a write-off on their taxes because it was an advertisement cost. So they were throwing kids up on these milk cartons right and left because there was a tax break for it. So it kind of diluted the whole thing anyways. And the truth of the matter is that if a child who's abducted is going to be killed, 67% of them are killed within the first 3 days, or excuse me, the first 3 hours. I take that back, 3 hours. And I believe it's like 40% of them are killed within the first hour. So the amount of time that it takes to get these kids on a milk carton, if they haven't been found by the time they're on the milk carton, the odds were they were already gone, unfortunately. So really all it did, well, I would argue that the concept was great and it was noble. I think it just created more and more fear in people and created an issue that didn't necessarily exist, at least not in a major amount. The truth of it is, when you look at the statistics, it's less than 1% of child abductions actually happen from people that the children didn't know. The vast majority of them come from a friend or a family member, and usually it's a custody dispute is where it happens. That's the majority of them. So this stranger danger movement that came off of this and everything else was really in a knee-jerk reaction to something that was, in the grand scheme of things, a very minor problem. But along the same time as this was ramping up, the stranger danger, the John Walsh on TV rather, pushing the crimes and showing off these missing children and talking about those cases and the milk cartons and the pizza boxes. Along that same time, we start to develop the internet, we start to develop gaming, and this excuse to move kids indoors. Let's give them something else to play with, where we've gotten to the point now where it is, you can't have your children outside unattended and have law enforcement drive by without law enforcement looking twice and going, what's going on here? And that's sad, because not only do you not have your kids getting out there and touching grass and, playing with other children and whatnot, it's almost become criminalized to let them be outside. But then I would argue that since we've done that, what have we opened up? Well, with the advent of the internet, we've taken what could potentially be a local issue, where in a community maybe you have a predator or two predators that might be known to people, so you know to avoid them and whatnot. And now you've opened it up globally so that your children are now not only worried about Weird Steve 2 blocks down. Sorry, Steve, I had to pick a name. But they're now susceptible to people everywhere, because we worked ourselves up in the 80s and the 90s into this frenzy about how dangerous it is for children. So we move them indoors, and we still need to give them things to pacify them or whatnot. And the internet comes along, so we put them on the internet. And now there are predators everywhere that have easy access to your children. And I think that it is this unfortunate series of events that has led us to this point where there is so much of this crime, because ultimately we've made it easy for them. We've created this lane where if they have such predilections, they've got easy access to so many, and they can vet them. It's not just driving up and going, "Hey kid, do you want a lollipop?" It's now they can spend time kind of courting the child online and figuring out if they're a good candidate or not to exploit. I don't know what the answer is. I was just thinking over the weekend about how did we get to this place, and I started replaying the events of the last few decades in my mind and how things have changed and how things have evolved. And I would argue that, again, it's just a series of unfortunate events where you've got You've got this movement away from being outside because everybody is riled up into this scared frenzy that really had no actual basis. And that comes along at the same time as the internet and gaming and all those things. And now here we are. Just my thoughts. Michael might know something different. What do you know, Michael?
Daniel, good morning.
Hi there.
Welcome to the 4th hour. This is fun.
Something different.
Yeah.
Anybody can
I will
watch
tell
Court.
you.
Let's talk about Court.
Exactly.
And law and rambling.
First of all, the child predator stuff that's out there. I mean, it's now Chris Hansen has, he's got hundreds of new shows out that Michelle and I watch a lot. It's called Takedown, and it's amazing. It's amazing how much grooming and how many weirdos. And look, we all think of Weird Steve, right? But it's not just Weird Steve. It's not just the creeper on the corner that we used to talk about in the 80s and 90s that we always just, don't go by that guy's house. He's weird. Now it's doctors. There are professionals. There are people that work at, hardware stores and retailers. And it's not just an unemployed loser that spent his whole life in his mom's basement. It can be anybody. And more likely, by the way, it's people that have that are working, that, have something going on. Now, yeah, there's ex-cons, of course, there's people of all walks of life, though. But, and it's people that are just, they're looking for whatever, and, they get lured into these things. But I mean, it's not just on, Takedown and, Chris Hansen. I mean, there's creepers on Roblox and all these other games that kids play, and there's a lot of grooming and a lot of weirdness that's going on, man. Obviously, the one that Michelle talks about a lot is Larry Nassar, the doctor that, this was a so-called reputable doctor and treated all these Olympic athletes and all these major, these up-and-coming athletes and all this kids. I mean, 12, 14, 15, 16 years old, and did all sorts of terrible things to him, and wasn't discovered for a long time, got away with it for a very long time. So, yeah, I mean, to your point, Dan, it's, I don't, look, man, is it worse than it was when we were kids? I don't know, but question mark on that. But, now it's, of course, we hear about it because of 24-hour news cycles and because everything is much more easily documented. And maybe and obviously that's a good thing, but it definitely changes your view of the world. That's for sure.
I think it might be worse, Michael. And the reason why I think that it might be worse is that as I indicated, we've opened up the playing field, because we got scared to let our kids be outside. We've brought them inside. And now with the advent of the internet and the advancement of technology,
anonymity,
kids are going to do something, so they're going to get online. But it's made this huge playing field now for anybody who, again, has these predilections.
Yeah, I mean, obviously, and with the population being bigger, I mean, okay, just by sheer numbers too, the population's larger anyway. Yeah. And yeah, you have easier access, and there's anonymity on the internet to a certain degree. And yeah, I guess, and this is for scams. This is not just, kids stuff too. I mean, there's so many, and there are people that are out there that are trying to fight all the scams and stuff. I mean, we watch a lot of that stuff going on too. The internet is definitely still the Wild West in a lot of ways. And, I have been labeled a curmudgeon many times for saying that I would never give my children cell phones. And I know I'm in the minority on that. But I wouldn't let anyone under 16 have a cell phone, at least not one that can get on the internet like that. Maybe a flip phone, where they could call people, but maybe a text, but playing games. Yeah. but maybe I'm too much. Maybe I'm too far over on this side, but that's just how I feel about that. It's gross, Dan. It's gross out there.
No, it really is. And you make an interesting point about the amount of scams and stuff too, and how, it's not exactly on this topic, but how that's become easier. And it comes at you from all directions. I receive 5 or 6 emails a day now from people who want to sponsor this channel. And all I have to do is give them my login information for YouTube so that they can go ahead and double check my stats and make sure we're a fit.
Ah, yes. I've seen a couple
right
of those.
Yeah.
Yeah.
I'll get right on that. No problem.
Yeah.
Look forward to the opportunity.
Website too. I've seen that. It's the same thing. And again, the internet has made access to all of that easier. We take advantage of people's lack of knowledge. It's of course, children and the elderly are the two that we most commonly see get scammed and get hurt by predators, and predators can mean all sorts of things. And that's the problem I have there. Now, Dan, shifting over to the other big topic, because I know there was certainly a disagreement in the chat.
I was going to ask if you had thoughts.
Lots of thoughts on it.
Right,
look, first and foremost, if you're terminally ill and you want to do cocaine and you want to do mushrooms or whatever the hell you want to do, I have no problem with it. I don't think there's a morality issue. I'm not the morality monitor. I don't care. It does not affect me one way or the other. And I'll tell you, if I was terminally ill, I don't know what I would do. I probably wouldn't do cocaine. I never have. I don't have any intention to do it. But I would probably be very high on, I would probably be doing a lot of weed, a lot of gummies, depending on what it is and my pain tolerance and what's going on. And that's on me. Now, I'm not going to go out and traffic it. And this is where I have a problem with this guy, is that he's out driving around, and that I do have a problem with that. But just for his personal use, or even if he had 5 ounces and he wanted to do, 10 lines a day, which I don't know, that's about 100 milligrams, give or take. You know what, man, whatever. And if you get caught with that much coke on you, but you're not trafficking it, I don't care. Now, if you are, then we have another conversation. But if you want to turn your house into a snow globe, I don't care. Doesn't bother me one bit. And I don't know, Dan. I know you have very different thoughts on drugs and all that, and we've certainly talked about that before. But just personally, for a terminally ill person, couldn't care less.
Well, I don't know that I care either if he's doing it personally. I guess where my problem is that he's caught driving around with a trafficking amount. Now, unless he can say and prove, yeah, I just got it from Big Joe over there, so I literally just picked it up, and throw Big Joe under the bus. Okay. But otherwise, I don't see a need for him to be driving around with 1,600 doses. Leave it at home.
Yeah. I mean, maybe he wants to stock up. Maybe he doesn't want to have to go out and get a lot of doses at a time.
Well, again, at that point, throw Big Joe under the bus. I guess that's kind of my point,
just say, listen, man, I got my Big Joe, and I had to drive by Weird Steve's house to get there, but I did. And Big Joe sold me the coke, and that's fine. And then let the chips fall where they may. Just don't be driving around high on coke.
Yeah, I mean, we all know Big Joe's the Costco of the drug world, anyways. So you're gonna buy in bulk from him. That's cool, but go there then. But he didn't, obviously,
right,
because we got to this point. So it's a matter of. It's a matter of him behaving badly. And again, from a morality standpoint, again, if you're truly terminal, I'm a believer in whatever it takes to medicate you.
Yeah.
You know, a little over a year ago, we lost Beth's dad, and we took care of him for 7 years. And in the end, we were doing whatever it took to keep him comfortable.
Sure.
And why not? I mean, we're not worried about an addiction at that point because he's going to die. It doesn't matter.
Right.
But it doesn't give you the excuse to potentially harm others. That's
right.
where
It's not carte blanche. It's not. Yeah.
That's where I can't go along with this situation. Again, if he'd had that amount in his house and, you know, he was out driving around and he had, you know, enough for a couple of lines with him, well, it's a simple possession at that point, whatever.
Yeah.
But the whole situation is just incredibly fishy to me.
It is. I agree with that part. I will say this though. Imposing fines and costs on him, I just kind of laughed at him. Like, what are you going to do if he doesn't pay it, Judge? Unless somehow they can get Judge Capper to pull him out of the ether and bring him into dungeon court. That's about the only time he's going to face any punishment going forward, I think.
Well, we'll see him in dungeon court in a few months because that's where all souls go to be judged.
Right. That's exactly.
So that's going to happen. But it probably, I would imagine, I don't know what Michigan law is, but I would imagine the court could put a lien against his estate.
I'm sure they could. They might be able to do that, but I don't know. At this point, the only thing I do think though is, I mean, at this point, why put him in prison? Just put him on house arrest. Just put him in. And that's it. I mean, there's no point. Putting him in prison, I think, is a little bit almost bordering on cruel and unusual punishment.
It might be, but if it's a trafficking cocaine situation, I don't know what Michigan's minimum sentence guidelines are for that. But Michigan has a lot of minimum guidelines. They're like loaded with them.
Yes.
So he might not. I mean, I don't know.
I thought like Judge Elmore was a little bit harsh on him. You know, again, I understand the danger to the community and I understand driving around high on coke. That part I do get. I just think that his overall tone with him, he said that he didn't care. I don't think it was a point where the guy didn't care. I mean, even up until a couple of years ago, he's operating like food truck businesses and stuff. He's obviously still out. He was still living, or at least making a living or trying to. I know that, you know, cancer treatments aren't cheap, even if you have insurance. And generally speaking, insurance is either going to barely cover it or not do a very good job or delay a lot of stuff. I mean, my brother just went through cancer treatment and, you know, and there was delays in getting PET scans and all, you know, like really important things. And of course it got done and he was fine. He's fine now, but still, it was not cheap. I don't know. I didn't even ask him how much, you know, out of pocket he was spending. So I can only imagine. And, you know, people get desperate. Now, I'm not saying that, it's okay to sell cocaine to pay for that, or it's okay to do whatever. To your point, Dan, maybe he should just, who cares? Who cares about the big insurance or the big pharmaceutical companies? Rip them off. What are they going to do? You know?
Yeah.
But I guess I just felt like Judge Elmore's tone overall was not where it could have been.
Yeah, I think some of that is a function of Judge Elmore. He is incredibly anti-drug, far more than I am, and he's been very clear on that point too. I can't remember a time when he didn't have a drug offender in front of him where he didn't talk about how it is not a victimless crime, despite what everybody says. So he definitely has his views, and he is not shy to share them. So I think that's part of the function as well.
And I even made a reference in the chat that he is harsher on drug offenders than he is with some child crimes. And that's been kind of chronicled here on TCF. I mean, I have seen him give drug offenders, one case in particular from several months back, 20 years. And there was a guy that was in front of him not long after that was doing stuff. We talked about child crimes on a computer. He was trying to, he had like an image or a couple of images, and he was like, talking to somebody or whatever. And that guy, I think he gave him, a total of like 15 months, or it was some ridiculously small amount of time. But then obviously he had to register and all that, and that's for life. And sure, that sucks, just like the arson offender, which I didn't know was a thing in Ohio. We saw today. But okay, but still, you're never going to be able to convince me. I don't care how much somebody sells drugs or how much drugs they do or how much whatever, that's worse than any sort of crime, especially a sexual crime against an underage person. It's just never going to convince me of that.
I would tend to agree, but that's just that's not just a Judge Elmore problem. That's an almost every judge we see problem. I jokingly talk about how if you're in Stevens court, he's going to sentence you to probation and then take you to the Sizzler for dinner that night. But I'm not really joking, because it's, I don't know what it is about that crime that so many judges just can't seem to get there. And in most situations, the law seems to allow for them to be harsh. It's not like, at least from the courts we monitor, it doesn't seem like their hands are so tied that they can't be aggressive with it. They just choose not to.
Yeah, and we see Judge Boyd hand down some pretty harsh penalties there sometimes. And that's about the only one I've really seen that has absolutely cracked the whip. And it's strange. It's maybe this is a sidebar topic, or maybe not. The very odd, the fact that some of these crimes that are, depending on state, but, here in Arizona, they're class 1, class 2 felonies, the upper end of felonies, class A, class B, whatever state you're in. And yet they're treated lightly, and there's psychological evaluation after psychological evaluation will tell you that almost invariably these people have no chance of recidivism, no chance of rehabilitation. They are going to reoffend when they are released in all probability. And yet they're treated like, you ran a red light a few too many times. Yeah, we're gonna really give you a big slap on the wrist, big one. Don't do it again, even though you will.
All of a sudden, you're not pleading guilty or not guilty. You're pleading responsible or not responsible.
Yeah. And that's my problem with this. And I think this is a system-wide issue. This is a problem. This is a much larger problem. We still are in this old school mentality in some states where, drugs are up here and child crimes are down here, or maybe we just haven't caught up to how predatory these people are now. We're like, oh yeah, if you snatch a kid off the schoolyard and you take him away someplace, and kidnapping, that is terrible. But to me, the grooming stuff and all this crazy stuff that goes on online, I mean, I just think that's as bad, if not worse, because it doesn't look as bad. It's not there in the public where you're just grabbing somebody and throwing them in a van and running off. It's just conversation online, and it's just, we're playing games together. But next thing you know, they're going to a mall to meet, Weird Steve, and that's it. And then they disappear,
No, it's true. I mean, we haven't caught up with the changes, and this kind of dovetails into my thesis about how we've gotten to where we are. But you talk about the drug laws being up here and the child laws being down here, but that kind of aligns with where we were at in the 80s, perhaps, because, you had the drug peddlers out on the streets, but your kids were out on the streets. So, so you're punishing that severely to, protect the youth, right? But now it's shifted a little bit. And in most states, I mean, hell, you can have your drugs door dashed to you now. Because it's legal in a whole bunch of places, So
Yeah.
it's not even like you got to try for that anymore. You just
Right.
get on the app and order.
I mean, you basically do, Dan. I mean,
yeah, it hasn't
and dispensaries
come
are so common,
up. Yeah.
It's especially here in Arizona, they're just popping up everywhere. Nevada, Colorado.
There's
I
one
mean,
on every corner.
they're almost, it's getting to be that way. We're right there. And again, I don't have a problem with it. It doesn't bother me. None of that bothers me personally. My only issue still is if we're going to punish things, if we're going to look at, we need to catch up with the technology. We need to, better enforce all this. I know that with AI, AI images and what constitutes a bad image, and that's going to be the next kind of, that's going to be the next hurdle to climb is, if someone has inappropriate images, but they're AI generated, is there a victim? Is that bad? Is that, that's going to be another, that's the next frontier, I guess, in that department.
That's going
Yeah. So, there's a lot going on here, Dan. There's a lot of stuff that we still have to figure out around the bend, I think.
Well, I think this is why you and I are starting a new show, Michael. Barbara, drop a link if you'd be so kind. But starting February 2nd, you and I in the blind.
Yes.
Where we're gonna talk and debate, but the hook for this show is we're going to have no idea going in what we're going to talk about.
Yeah.
Those topics will be provided to us in real time.
It could be this. It could be something completely different. Could be toppings on pizza, which I have a bad feeling that would be like the worst one, probably.
Probably.
It'd probably come to blows at that point. Yeah. Well, that's being written down right now, I'm afraid. Yeah. Because it is well documented, Dan. No two people in the history of humanity have ever been able to agree on pizza toppings.
Yeah, I think you're right. Well, maybe we should have that fight then. All right, I'll suggest.
Yeah. I mean, talk about never being able to resolve anything, which is what our tagline is for Sidebar. We don't actually resolve anything except for the one time that we did.
Yeah, and I private that episode.
Yeah. Take it down. It's going to get demonetized. Copyright strike. How dare you? Yeah. So yeah, Sidebar tomorrow night, 8 p.m. East, 5 p.m. Pacific. Tune in for that. And yeah, the In the Blind with Mike and Dan coming February 2nd. We'll have a pilot episode before that. So lots of things to look forward to. This fourth hour is this is awesome, Dan. I really I like the direction. I really do.
Yeah, we'll keep evolving it. Thank you, Michael.
Yes, thank you, Dan.
Talk soon.
Bye now.
All right, my friends, one last thing to wrap up the fourth hour. This is just a news headline that caught my attention as I was going through stuff this morning, and I think it might be a case that we'll keep an eye on as it develops. But this is something. Pennsylvania man allegedly found with over 100 sets of human remains in home storage unit, quote, horror movie. Pennsylvania man facing hundreds of charges after over 100 full or partial sets of human and skeletal remains were allegedly found in his home in a storage unit in a scene a district attorney described as a horror movie come to life. Jonathan Gerlach, 34, was arrested by police who were investigating a string of burglarized graves and mausoleums in the Mount Moriah Cemetery on the outskirts of Philadelphia. Quote, detective walked into a horror movie come to life. This is an unbelievable scene that no one involved, from myself to the detectives to the medical examiners that are now trying to piece together what they're looking at. Quite literally, none of them have ever seen anything like this before, said District Attorney Tanner Rouse. Detectives have recovered an awful lot of bones at this point, and we're still trying to piece together who they are, where they are from, and how many we are looking at, and it's going to be quite some time before we have the final answer, noting that some of the remains were months-old infants, while others were hundreds of years old. Delaware County District Attorney said around 8 p.m. on Thursday, police were conducting surveillance of the Mount Moriah Cemetery when they observed the suspect's car with numerous bones and skulls in plain view in the back seat of the vehicle. Gerlach was then seen exiting the cemetery holding a burlap bag, crowbar, and other assorted items. The offender was brought into custody where he admitted to stealing approximately 30 sets of human remains. Though investigators believe it's over 100 full or partial sets of human and skeletal remains. So I'm gonna keep an eye on that story because that is crazy. Barbara thinks he's selling them. Maybe. That wouldn't somehow surprise me. Yeah. I don't know what's wrong with this world. I really don't. But this is why we have TCF, so we can watch it and try to figure it out. Though I'm not sure we'll ever get the answers, much like Sidebar, where, we solve nothing. All right, my friends, that brings it to an end for today. Feel free to let me know in the chat what you thought about the 4th hour, and if there's different things you'd like to see or like us to do or whatever. I'd appreciate your feedback. It'll continue to evolve as we go, but I wanted to have the opportunity to have discussion and opinion and thought rather than just watching court. Let's bring it all together and talk about it a little more. But we'll be back tomorrow. What are we, 9 a.m. Eastern, 6 a.m. Pacific now? That sounds right. 30 minutes early for channel members, and we'll have Sidebar tomorrow night, 8 p.m. Eastern, 5 Pacific. And yeah. So go have yourselves a great Monday. I look forward to seeing you all tomorrow. We'll have some stuff posting throughout the day, so be sure to check back on the channel. Take care. God bless.